Judgment. In this, we have taken into consideration the object with which 319 came into force, then taken note of Hardeep Singh and Shashikant Singh. Both we have said are not wrong. And since Hardeep Singh says that judgment, then we have tried to explain what is that, which is the period when which the trial comes to an end, judgment means. So there we have said, insofar as acquittal is concerned, this power should be exercised before acquittal order is passed. And in cases where conviction is there, it is before sentence. And in any case, if it is on the same day, it has to be shown that this power was exercised before the sentence was. So in those circumstances, we have answered the questions, only those parts I'll just. The first question was whether the trial court has power under section 319 of CRPC for summoning additional accused when the trial with respect to other co-accused has ended and judgment of conviction rendered on the same date before pronouncing the summoning order. Answer to that is the power under section 319 of CRPC is to be invoked guidelines for the trial court that we need not read here. Having answered the questions referred in the above manner, we direct the registry to obtain orders from Honorable the Chief Justice and place before the appropriate bench to take a decision on the factual aspects arising in the case in the background of the legal position and contentions on merits. Before parting, we place on record our appreciation for the assistance rendered by all the Leonard Senior Counsel/Counsel, including Shri S. Nagamuthu Leonard Senior Counsel, who assisted the court as an amicus curiae.
ಚೆನ್ನಾಗಿ ಬಂದಿದೆ
Very good.
Lots could resume may make a small request minutes.
Yes, Mr. Naidu.
501.17 minutes. I represent the petition in this one, which is a cooperative bank, a district cooperative bank.
But now the grievance of the cooperative bank no more survive now.
Minutes, I am told, we have raised only a collateral issue. Perhaps I was told it's not been addressed because it could be detacked. The grievance is that minutes, when it comes to acceptance of these notes, we were given a cutoff date between 10 and 14. But what we got accumulated to turn of 15 crore rupees on 8th, that's not been there. We have said it's arbitrary, that has to be looked into.
Take care of your interest also. If you want, you can address on that issue also.
So be it.
You can address your arguments. We will permit you to
Sure.
address.
That, as Mr. Dewan has already argued that the power has to be considered as a power coupled with duty.
duty under that subsection 2 of
2 of 4. Subsection 2 of section 4.
Well, this
That-
aspect is completely different. This is about banks depositing notes, not individuals.
no, that we
It's
will
a different issue, Millard. There are different notifications.
He wants it to be detached.
Millard,
no
Yeah.
detag means it has to go again before a judge or 5 judge. 2 judges.
Millard, I'm told 9 such matters are not part of this batch. There is no order perhaps for reference for constitution bench. The issue, Millard, partly is
Seven minutes.
1
50.17.
so and so and so. 3 so and so learner senior counsel appearing on behalf of the petitioner submits that the issue involved in this case is distinct, and that similar issues are pending before a 2-judge bench in 9 other cases.
Minutes. I'm told minutes.
But I'm told it's 9.
All right.
Your lordship didn't mention the figure, but there are matters pending, Millard, which are not before your lordship.
Other 9 other cases which are so and so and so. You put a draft and give it. Therefore, this petition is detacked and list this case along with the other cases pending before the 2-judge bench.
So Gupta, ask someone to give the number of those matters.
I will give. Well, that last appeared before Chief
All
Justice
right,
Lalit.
Shri Jaideep Gupta, learned senior counsel representing the RBI is requested to furnish the other cases pending on this
Yes.
question, so that this case can be, and tag this case along with those cases.
Very well,
All
very
right.
well.
Chalo.
May I humbly submit?
Yes, yes.
I am waiting for my turn.
Hmm.
I believe today London AG will take time and other will not give it. So I hope tomorrow I will be given a chance to take this. one.
All right, sir, all right. Hmm.
Oblige your lordship.
Your Worship, there are some SLPs and transfer petitions and IAs which are related to question number 9, Your Worship. So, Your Worship, I believe Your Worship is not de-tagging those matters because our matter should be heard here only, Your Worship.
Right? And we are not deciding the case on merits rather, on facts.
Your Worship,
And you can go and, you can argue later, no, whatever.
but question 9 should also be decided by this honorable right. Your Worship. My humble submission is this only, thereafter. we can go before other-
Then you can argue that question 9 also at a later point, now that the AG is,
Yes, I just got some confusion.
all right, you can argue, no issue.
That is like.
Well, if all the district cooperative bank matters go out, then that one question probably your lordship will not be answering in this.
So whether they are also referred, any question is referred on those,
The one question on DCCB banks is referred.
then letter address, then you can argue
Yes,
later.
yes, Lord.
Letter,
Not saying your lordship has to.
no, if
answer.
that is also referred, then we will answer that question also.
Well,
Side that issue.
See, we don't know.
so if your lordship wants to keep that aside, then this question should not be answered by this circular. It can be answered later on.
There's so many.
Which question? I'm sorry.
Yeah, the question,
number
Lord. Question
they are
number 9 of the
whether they are
original question.
discriminated.
Whether the DCCBs have been discriminated or not.
That's it. All right.
Worship, there are so many other matters which are.
All right, there are many matters in the Supreme Court. There are 70,000 cases. There are 70,000 cases. All right, let us see. Let us make a beginning at least. There are 70,000 now.
You please, your lordship.
All right.
Hand over. I have
Yes,
a
sir.
additional note of submissions.
Yes.
What I propose to do is I'll take your lordship through this note. As I run through this note, I will address some of the questions which I did not answer on the last occasion regarding interpretation of section 26, etc. I will run through them. And thereafter, I don't propose to read in extenso judgments in support of my argument. I'm giving a list of them with a short, extract from the relevant judgments.
All right.
And then the 6-7 points of arguments relevant of advance. I've tried to prepare again a brief note in respect to each of the arguments so that will supplement my written note.
Yes.
I'll conclude with that.
Yes, right.
Don't want to use our pen.
Yes, sir. Please proceed.
I think we should conserve your lordship's time and see as precisely as possible. I try to advance the
It's
argument.
very nice of you.
You're right. Yes, sir. The first submission in my note is regarding the excessive delegation. And just quickly, headings I'll just quickly run through, and then your lordship turn to page 4. I look at the procedure under 26(2). Then we go to the interpretation of section 26 on the meaning of the words any, etc. Then page 10, I try to look at how when the Act has virtually incorporated the notification and refers to it in section 3, the notification has been affirmatively dealt with by the Parliament, and the notification does not exist as an independent instrument of law. And Parliament has applied its by notification. Therefore, what we'll be looking at is the parliamentary law and not the notification. Then at pages 11 to 13, we are looking at the dates, choice of dates, and why there is no arbitrariness in it. Then at page 14, I was trying to look at the proportionality test, why it is not applicable here. Then lastly, at pages 17 to 18, we say that an argument raised that the notification has failed to achieve the objectives. A very important argument. That a person with a rich experience about governance and finance and all that comes and makes an argument that you are chasing illusory objectives. I say this is not a ground on which a law or an instrument of law will be struck down. Something very strange has been advanced before the court, and a very responsible argument. So I would like to look at that. Kindly now come back to my page 1. Page 1, para 1.1.
Yes.
Section 26(o) does not constitute excessive delegation, cannot be prospectively overruled. There are two primary reasons why Section 26(2) cannot be considered as
But
excessive
Mr.
delegation.
Attorney,
Yeah.
Mr. Chidambaram has appeared as a counsel.
Your Lordship, please, sir.
Mr. Chidambaram has appeared as a learned counsel for the petitioner.
But he comes with him as a rich experience of being a finance minister. He may be a counsel. But
The question would be, when the objective at the inception was valid, assuming that it is not achieved, would it invalidate the action?
certainly not. Certainly not. I mean, the every minute of governance looks at targets. Or a 5-year plan have targets. And then over a period of time, the targets either met or not met for a number of reasons. Therefore, the targets become bad.
Yeah.
The last occasion that look at the benefits flowing over a period of time. And
Mr. Attorney, there is a challenge to 26(2) also.
I'll come to it immediately.
A twin challenge.
It is part of my
One-
return note.
First challenge that it has to be for any currency and not for all currency. And if it is not read down in that manner, then the section has to be held to be giving an excessive, uncanalized, arbitrary power, and therefore not valid in law.
I know, that's why I tried to put it in a,
Interpretation is one part.
Your Lordship, please.
Challenge is the other part. Interpretation of 2060 is one aspect.
Right?
Challenge to the 26.2 as it is. So Mr. Chidambaram said it has to be read down.
My first response is, why should it be read down?
We don't know.
No, the arguments are it is uncanalized, unguided, therefore it violates certain constitutional provision. It should be read down to save it. Reading down is a device which courts have evolved to save a law or an instrument of law from being treated as invalid or
Yes.
unconstitutional.
Yes.
So the DTC Mazdoor case, the state of West Bengal, all those long line of cases reading down, you want to save the law. But while saving the law, you want to read something into the law, so the law survives. So if the anxiety is that 26.2 being uncanalized should be struck down, then why should we go beyond that and say let it be struck down? So there's a conflict in the arguments I'll try to propose.
Okay.
That's right.
All
Right. That's why I thought I'll read it and then it will be clear as I go
All
forward.
right, sir. Great.
And then I'm trying to point the last occasion, it is not that the targets have not been met. You have to look at from a certain range of period and how they have merged into one another and how each target, income tax, PAN return, so on and so on and so forth. I've let all those details. So over a period of time, if it has ushered in a certain framework, the court will look at the larger framework and not look at what happened immediately after the next day of the notification. So on matters like this, you must have, according to the petitioners, you must have a standard. I'll bring that scale of standard and find out how quickly you achieve the targets, or how quickly you fail to achieve the targets. I say that's not possible in matters like this at all. The court will only look at the unfolding picture over a period of time. And if this withdrawal of legal tender is one important element to be introduced into it, don't look at it in isolation at all. But you want to look at it in isolation, then we have a different picture. Then every policy where a tool or an instrument is pressed into service, you will not look at the larger picture. You will only look at the tool or the instrument. You may have any number of objections to it. Right.
Yes.
Para 1.1. There are two primary reasons why Section 26.2 cannot be considered as excessive delegation. The first is that Section 3 of the RBA Act, which has neither been challenged nor even adverted to by the petitioner, grants or rather transfers the complete powers of the RBI for the purposes of taking over the management of the currency from the central government. The preamble also makes it clear that the RBI was created to regulate the issue of banknotes and the keeping of reserves with a view to securing monetary stability in India and generally to operate the currency and credit system of the country. RBI is not just like any other statutory body created by an act of legislature. It's a creature, creates a mandate to get liberated even from its creator. Then taking over the management, that's footnote 1, the largest cryptocurrency judgment, well, the Ramsman will get it in greater detail. And taking over the management of currency and regulator words of the widest import, and no rules of interpretation would support a narrow interpretation. It is said that the power to regulate something is wide and includes the power to prohibit. Any restrictive interpretation of these provisions, Section 26, would do violence to the very intent and scope of the RBA Act. The second is that the transfer of such powers is not delegation of power, as is understood in the context of delegated legislation. Just passing here for a minute. Ordinarily, you look at a rule-making power given to under the Act or a power to exempt. These are by and large situations when a delegate legislation comes into question. This is not one such case at all. I'll try to point out. And therefore cannot be tested on the parameters thereof. What is taking place by virtue of Section 3 of the Act, read with the other provision therein, is the transplanting of the primary responsibility of currency management in the country from the domain of the Union Executive to an expert body, the RBI, which acts through its board, set up exclusively for this purpose. It is not the case that Section 26 empowers a further authority or a delegate to exercise its powers. The transfer of powers of management of currency by itself or any part thereof cannot suffer the vice of excessive delegation. Now, those provisions I've set out here, preamble and regulate, Section 3 taking over, Section 17 bracket 15 making and issue of banknotes subject to the provision, 22 right to banknote, 23 denomination, 26 legal tender. I read all those provisions in the last occasion. Next. The RBI is specifically empowered to do certain things to the exclusion of even the central government. Therefore, to place its decisions on a pedestal lower than that of an even executive decision would do violence to the scheme of the Act. Then that is again the internet judgment will throw some light. The inescapable conclusion to be drawn from a combined reading of the provision is that the power of RBI with respect to the management and regulation of currency is complete and not capable of being circumscribed without severely affecting the working of the Act itself in its current form. Very important. Anything with section 26, you are probably dealing with the spine of the legislation. So let it be an erect spine, not a spaghetti spine. Therefore, without challenge to a section 3 that's overly wide, there can be no challenge to other provisions of the RBI Act, which are in furtherance or other specific instances, kinds of such regulation management. Court will not lightly therefore interfere with economic legislation, particularly in the context of RBI, as the interdiction will have wide-ranging consequences. Then, as regards the second limb, when seen in the above conspectus, it cannot be argued that section 3 suffers from the vice of excessive delegation. I'll just quickly run through the few of these judgments. As laid down succinctly in Municipal Corporation of Delhi versus so and so, under the Constitution, the legislature has the plenary powers within the allotted field. Essential legislative function cannot be delegated by the legislature. That is, there can be no abdication of legislative function or authority by complete effacement or even partially in respect to a particular topic, a matter entrusted by the Constitution to the legislature. Power to make subsidiary or ancillary legislation may, however, be entrusted to the legislature to another body of its choice, provided there is enunciation of policy, principle, or standards, either expressly or by implication for the guidance of the delegate in that behalf. Entrustment of power without guidance amounts to excessive delegation of legislative authority. Mere authority to legislate on a particular topic does not confer authority to delegate the power to legislate on topic to another body. The power conferred upon the legislature on topic is specifically into the body, and it is necessary intendment of the constitutional provision which confer that power. It shall not be delegated to living into principles, policies, standard, or guidance another body unless the Constitution expressly permits delegation. Further, this case is also held what guidance should be given and to what extent, and whether guidance has been given in a particular case at all depends on a consideration of the provisions of the particular act with the courts of deal, including its preamble. Further, it appears to us that the nature of the body to be delegation made is also a factor. The body to be delegation made is also a factor to be taken into consideration. We'll have any number of instances where an administrator under a statute or a collector, somebody is given authority to do something, fix a rent regarding a rent fixation, or exempt a body from the application of the act. Look at the level of those persons. We are talking about RBI. Therefore, a factor which will be taken into account is who is the person who is entrusted with the body, to discharge functions under the act. And 1.5. These principles may be applied to the RBI Act. First, as held by this court, the RBI is not a mere statutory authority. It has the mandate to deliberate even data, and its decisions cannot be placed at a level even below the executive decision. This itself militates against the possibility of the functions and actions of the RBI and the RBI Act as being delegated. Second, the RBI itself is the sole authority managing the currency of the country. There is no question of it being delegated essential legislative functions. Consequently, questions of guidance from the legislator or the executive for exercising the functions by RBI also cannot arise. And finally, as stated earlier, it is not a case of the RBI delegating its functions in any manner to any other body or authority which would invite the application of the opposite principles.
I feel that their argument is that there is an excessive delegation to the central government.
Central government acts on the recommendations of the RBI. Acts on the recommendations of the RBI.
And I think they don't have any quarrel with your proposition that the RBI has supremacy. So their argument is that the RBI has supremacy and therefore the proposal ought to have emanated from RBI.
I'll address that argument very soon. I look at section 26, I tried to point on the last occasion. It's a very unique provision. You're looking at the management of currency and declaration of certain instruments as legal tender, and withdrawing them from legal tender, right? In this, is it possible to suggest that RBI will act in an isolation or the government will act in isolation? So I tried to tell your lordship that both the RBI and the government in an important monetary policy of the country, where Section 26 aids both of them. It's a source of inspiration, acting for both of them. So in that context, there is no question of delegation to either the government or the RBI. They act in consultation, recommendation from
They have to act
RBI.
together. They have to act together.
That's right. Consultation need not be necessarily expressly stated in the provision. It is the lifeblood of the whole act. Therefore, to say that the law should have said government will act in consultation, the consultation with the following parameters, you will write down everything about consultation, draw your minutes of consultation. No, not necessary at all. Your lordship knows in the context of Chief Justice's recommendation.
Debate on consultation.
So in the context of Chief Justice's recommendation, consultation, you're going to say consultation, concurrence, we try to equate them, consultation, a very flexible principle. But the flexibility of an instrument of law, given the functions it has to discharge, that will be kept in mind.
If you have considered that argument in subsequent paragraphs, go on.
Right. Distinguishing cases cited with the petition in relation to excessive delegation. In this case, the impugned provision related to an administrator designated in the Gold Control Act of relevance in determining the issues was that there were provisions parallel to those of the administrator, which require the rules made under the Act to be placed before the Parliament. In this context, the court held the powers granted to the administrator were too wide and suffered from excessive delegation. So two things. One, the administrator and not the RBI. So look at the difference, the level, the status, the function.
Nature of the body.
Right. This is not the position so far as Section 26 is concerned. There is no further delegate except with discretion with respect to powers under 26. Then Hamza Dawakana. In this case, the power to make rules designate specific diseases or conditions in the schedule. The Drug and Magic Remedies Adjustment Act 1954 was under challenge. On the ground that there are no parameters laid on the basis of which any disease or condition to be added there too. No parallel may be drawn here too. The designation of diseases or conditions to be covered by the statute has to be done on a scientific, determinable base of criteria, absent which it could ostensibly be arbitrary. However, it is impossible for the legislature to prescribe all or even an indicative set of reasons or circumstances under which the banknotes can ought to be demonetized. Doing so would cripple the powers contemplated by Section 3 and severely restrict the ability of the RBI to manage currency. Next. The procedure laid down under Section 26 was followed in the present case. The scheme of Section 26(2), providing for an interaction between RBI and the central government, must be seen a very special policy perspective. The use of the word recommendation deserves to be seen in the context of the integrated role that we played by RBI and the central government acting together in promotion of public interest. The word recommendation must therefore receive a flexible approach, since the subject matter of legal tender and the cessation of banknotes as legal tender are not matters that can be dealt with merely and exclusively by RBI. It is sufficient for the purpose of Section 26(2) that emanating from a consultative process between RBI and the central government, a proposal issues out from the RBI. It is inappropriate to suggest that matters of policy relating to the three objectives, purposes set out in the notification dated so and so must come as a measure of recommendation from the RBI. It's sufficient that RBI plays its facilitating role by discharging the measure of making a proposal to the central government. That's what has happened here. It would be naive and a matter of serious economic fallacy to suggest concerns such as terror financing, black money, and fake currency need not be seen as touching upon or impacting the subject of cessation of banknotes as legal tender and vice versa. Consequently, the idea of recommendation in Section 26(2) will fundamentally vary from its dictionary meaning or its occurrence in any other legislation. Next.
If your, 1 second, Mr. Attorney General, if your argument is that the consultative process must be there, and therefore it is all right for the central government to initiate this measure and then submit the proposal to the RBI in consonance with the central government proposal, what happens?
The two in 1990
They brush aside the
in
RBI
provided, let me answer from a policy perspective again. Then we are looking at a hypothetical case for the purpose of construing section 26. What happened in 1996, Jayanti Lal? What happened? It happened, the parliament wanted to do the law. RBI did not play any role at all. This court said there's a valid law.
No, we are not on that. We are testing your
I know, I'm
argument.
trying. Therefore, there can be instances when parliament wishes to act. RBI may have a point of view, but the parliament can certainly say, I don't agree with you.
Inside the parliament, because here it is not by an act of parliament, is not envisaged under the section.
I'll come to it.
What's envisaged is notification in the Gazette of India.
Correct.
Therefore, if parliament did it on those two occasions, it is the wisdom of the parliament. But that is not a mandate under 26(2) that it has
Certainly not.
by parliament.
Certainly not. But
But
you know,
suppose it emanates from the central government and the RBI in its wisdom thinks that it is not the right thing to do right now or not the right thing to do at all and gives its proposals to the central government. What happens then?
no,
Will the central government brush it aside?
the answer will come in a given case where we have those differing perspectives.
No, we are saying.
No, in a case, facts, then the court will find out whether the difference in perspective, whether the ruling out the central government saying, I don't agree with you, then the court will probably look into it at the preliminary level.
Question is
What
whether the
I just
central
allow me to
government is
develop.
bound by the
I
recommendation.
just
of-
allow me to develop the point.
Yes.
So therefore, the central government need not necessarily be bound in a case where it has a disagreement with the RBI. Then what's the role for the central government? Would the central government do an issue notification? Moot questions. But here in this case, as what happened later, the notification has now merged with the Act of Parliament. 2017 Act says, I refer to the notification. Therefore, that question of disagreement, what will the central government do, etc., may not be necessarily arise in this case.
No, we are testing your argument.
I know, I'm right. I'm only trying to say then it does not arise in this case. But in a case where it arises, it must be in the context of a fact. In that context of a fact, the court may find out whether there are, again, maybe that's a moot point. The court may decline to go in that question. The court may say, well, yes, government may, in its policy perspective, not as a delegate, as a sovereign power, even though government is as a statutory authority under the Act. But government acting as a sovereign power can still disagree with the view taken by RBI. But we don't have to get into a speculative question of whether it can happen or not for the purpose of answering this case.
No, for the purpose of interpreting.
Quite right. I'm not saying, that's quite right. That's a very important question. But it may arise in a case where the fact situation would warrant an inquiry into that nature. Where a fact situation does not warrant, perhaps this question will be a moot question. Kindly let me allow to go further. Para 2.3. The recommendation by RBI will therefore not be subjected to strict or close judicial scrutiny. Given the scheme of the Reserve Bank of India Act 1934 and the amendments made to the preamble thereto, it must be taken that RBI is just not any other expert body, but a very special institution charged with the duty of conceiving and implementing various facets of monetary policy. In the discharge of the duty, there cannot be any straightjacket formula. The nature and wisdom of the decisions taken within the framework of the scheme of RBI Act and its signposts and roadmaps set out in the preamble will always deserve deference. In keeping with the above understanding of the scheme of section 26(2), it is submitted the proviso carries sufficient safeguards that can be gathered from the various provisions of the RBI Act, including the preamble. The suggestion that section 26(2) is an impermissible delegation of legislative power in misconceived is also not in consonance with the law declared by the Honorable Court. In similar situations where the opinions or recommendations of an expert body or set of experts are concerned, the Honorable Court has repeatedly stated it will not sit in appeal over the decision and leave it to the experts who are familiar with the problems they face. This is even more so in the case of economic policy decisions obtained by the Honorable Court in Bajaj Hindustan Limited, so and so. Economic and fiscal regulatory measures are a field but judges should encroach upon very warily, as judges are not experts in this matter. The impugned policy parameters were fixed by experts in the central government, and it is not ordinarily open to this court to sit and appeal over the decisions of experts. We have not been shown a violation of law in the review notification or a press note. It is submitted there are no compelling reason or constitutional grounds for persuading the Honorable Court to enter into the scheme of section 26(2), its dissection, or advising on the exercise of the respective powers conferred on the central government and the RBI. It is submitted there are no flaws in the decision-making process, keeping in mind the daunting task of addressing the three challenges referred to in the notification. Difficulty is an issue that might have arisen in the course of giving effect to the notification, and the 2017 Act cannot be said to be flaws affecting the decision-making process. The evidence-very reasonableness or any such corresponding principle may not be of strict relevance. The very idea of entering into reasonableness of the need to address the three factors and their impact on the economic system of the country is open to debate. The three factors are terror financing, fake currency, and black money. I repeat, the very idea of entering into the reasonableness of the need to address the three factors and their impact on the economic system of the country is open to debate. The subjects of black money, fake currency, and terror financing are being studied over a period of time, and information and data gathered from various agencies of the Government of India are available. The 2012 white paper on black money throws light on the complexity of the problem. It would be naive to suggest that the government does not update itself on the above issues, which forever threaten or affect the economic stability and the currency management. It's further naive to suggest that there should be a need for a detailed survey and a study having regard to the enormous impact on citizens' rights by the decision if need to be taken on above issues. From the accounts of hardships that have happened, it cannot be canvassed the Union of India did not apply its mind and was not guided by a study. Next, the proper construction in a series. Section 26(2). Before I take a lordship, I just want to read one judgment of the US Supreme Court. Just hand it over. The lordship may come back to page 5 where I was referring to Bajaj Hindustan. The classification of the ordinance. I'm sorry. The attack of the complainant is upon the classification of the ordinance. It is contended that the purpose of the ordinance is to raise revenue, and the classification of the relation surplus, and therefore is arbitrarily discriminatory and thereby affect the 14th Amendment of the Constitution of the United States. The character ascribed to the ordinance by the Supreme Court of the state is not without any uncertainty. But we assume, as complainants said, that the court considered the ordinance the revenue measure only. The court said the ordinance will be sustainable on the taxing power alone, without reference to reasonable as a regulatory measure. Regarding it as a revenue measure, complaints attack is unreasonable in basing its classification upon the price of admission of particular theatre and not upon the revenue derived from therefrom. And to exhibit the discrimination which is asserted to result, a comparison is made between the seating capacity of complaint theatre and the number of their performances that are giving within a given period and the theatres of others in the same respect as resulting revenue. But these are accidental circumstances and dependent, as the Supreme Court of the state said, upon the advantages of the particular theatre or choice of its owner and not determined by the ordinance. It will immediately occur upon the most causal reflection. The distinction of the theatre is not artificial and must have some relation to the success and ultimate proof of business. In other words, there is a natural relation between the price of distinction, price of admission revenue, some advantage certainly, that determines the choice. The distinction obtained in every large city of the country. The reason for it must therefore be substantial. And it is so universal in the practice of the business scheme, government not unreasonable if it to be adopted as the basis of governmental action. If the action of government of such a basis, it cannot be declared to be so palpably arbitrary as to be reflected in the 14th Amendment. This is the test of its validity, as we have so many times said. We need not cite the cases. It is enough to say that we have tried, so far as the amendment is concerned, to declare in words, and the cases illustrate, for example, the wide range which legislation has in classifying as object. To be able to find fault with the law is not to demonstrate its invalidity. It may seem unjust and oppressive, yet be free from judicial interference. The problems of government are practical ones and may justify if they do not require a rough accommodation, illogical it may be, and unscientific. But even such criticism should not be hastily expressed. What is best is always not discernible. The wisdom of any choice may be disputed or condemned. Mere errors of government are not subject to our judicial review. It is only so palpably arbitrary exercises that can be declared void in the 14th Amendment. Now let me proceed further. And
you would have required 100 pages to write it.
Come on, bro. Come on, bro.
I, Twenty-six two. Any unguided, uncanalized, and arbitrary power in the executive. It is fallacious to read section 26.2 in isolation. It's further fallacious to close one's eyes to the very intrinsic dynamic scope of a provision of section 26.2 in the context of managing monetary and financial policies of the state. Section 26.2 cannot also be seen as a mere demonetization measure without reference to any number of factors, aspects, and challenging confrontations affecting the economic system of the country and its stability. The comparison with the 1946 and 1978 legislation is superficial and misconceived. In the case of both the said legislation, recourse to section 26.2 was not undertaken. Parliament intended to act swiftly and on the need to act so. As is submitted here and below, the 2017 Act rightly addresses the issues relating to cessation of legal tender, provisions for exchange of banknotes in order that Article 300A is complied with, and also the question of the liability of RBI under Section 34 of the Act. The petitioners have laid emphasis on the language of Section 26.2 insofar as it only permits cessation of legal tender for any series of banknotes of any denomination, with the interpreter to exclude a situation where all series of banknotes of particular denomination are demonetized in one go. It is a well-settled principle that courts will strongly lean against the construction of a provision which will reduce it to a futility. The following statement of law is also equally well settled. If the choice is between two interpretations, the narrower of which would fail to achieve the manifest purpose of the legislation, we should avoid a construction which would reduce the legislation to futility and should rather accept the bolder construction based on the view that Parliament would legislate only for the purpose of bringing about an effective result. An effective result, very important. The word any preceding, the word series, must therefore receive such construction that will effectuate the policy of section 26.2. At any given point of time, there will be several series of banknotes relating to a specific denomination or all denominations. The object of enforcing cessation of legal tender will therefore necessarily address the denominations in questions to be dealt with. It will always be a matter of great sensitive policy decision-making for the government to tackle matters such as terror financing, black money, and fake currency for the purpose of ensuring stability and integrity of the monetary system and its connection with and contribution to the economic well-being of the country. Once the government decides on the number of denominations to be dealt with, the policy perspective will dictate the number of series to be reckoned. Given the free play in the joins conceived in section 26.2, the word any preceding the word series must receive purposive interpretation. In this regard, it's worth noting that the word any is commonly interpreted to include all. In fact, even in legal parlance, it's been held that any can very well be used to indicate all. If the word any has just been read to mean all in varied circumstances, obviously, depending upon the context, it must necessarily mean all under section 26.2 in order that such a special provision in a special legislation is enabled to fulfill very important policy needs built into the scheme of section 26. As already submitted, the focus under section 26.2 will be on denomination, vis-a-vis the volume and quantum of circulation of the denomination, and the need to deal with the denomination for the purpose of addressing the three factors, namely terror financing, black money, and fake currency. It will therefore be futile to suggest that only particular series of denomination must be picked up. Consequently, the question of reading down any series to mean particular series cannot arise. The invocation of the principle of reading down is therefore misconceived. The law in regard to reading down does not envisage its application to provisions such as section 26.2. Even as a practical matter, the petitioner's argument cannot be accepted insofar as it leads to an anomalous situation wherein the government would technically be permitted to issue separate notification for each series, but will be prohibited from issuing a common notification for all series. The former course of action would in fact likely lead to chaos and uncertainty, whereas the later course of action would likely negate any such concerns. The word any would also mean all, depending upon the context. Then we have these judgments. 1962 Chief Inspector of Mines. Any one of the directors in section so and so means only one of the directors or every one of the directors. Then Banwarilal, any one and section so and so interpreted every one. Then the next one, in action seeking damages for defamatory statements given by the members of the parliament, while interpreting Article 1052 of the Constitution of India, it was held that anything is the widest import and the equivalent to everything. In the LDA, next, in Section 2O, Consumer Protection Act, service of any description was held to mean one to all, from one to all. The next, in CIT, any case in the Section 127 of the Income Tax Act was held to mean all. Then next one, any order or decision of the appellate tribunal was held to mean all. So any number of we can multiply the instances, and I'll give a few more. Then para 2.4.11, a word more than once in a section can have different meaning. Section 26.2 uses the word any twice. However, the meaning of any would be different in view of the context in which the word is used in section 26.2. The first use of the word any would mean all, but the second would use the word any or to be singular, or thus the central government can exercise its power under section 26 to declare any or all series of a given denomination to cease to be legal tender. So when you say any denomination, the government will find out what are the denominations which are broadly relatable to all those three factors, or currency management. So it pick up 500,000, 2,000, or maybe all, may only a few. Therefore, the dynamics of interpretation of the word any in relation to series may not be the same thing as you talk about any denomination. So such denomination which would address the question to be tackled with. Therefore, that's how the section 26 will have to be interpreted. I've given few instances here, and now kindly. Hand it over to your lordship. I don't propose to read them. This is what the code. Good, Master. I'm so there's a small pencil mark here, note here. The Lordship may kindly ignore that. Series of banknotes, working definition. A series, though not defined explicitly, ordinarily refers to the banknotes with common design elements, security features, having been issued over a period of time. A change in series is typically characterized by significant change in design elements and security features. Whenever there is a change in a banknote, such as the introduction of a new security feature, any change of design of the banknotes, change in governor's signature, etc., because sometimes governors occupy for a certain period, etc., and the numbering pattern in the notes is reset and restarted. The numbers in the banknotes can be repeated within and across series. Thus, a number of series cannot be termed as a banknote series. Then, third, mere addition of one or two features, example, rupee symbol, bleed lines, etc., is not considered as a new series. A change in series is typically characterized by significant change in design elements, security features. A change in series ordinarily spans multiple denominations. For example, 2005 MG series is introduced with set of additional security features, latent ways, etc. And MG series issued in 1996 did not have a security feature. Whether multiple issues of banknotes takes place in a series. Multiple issues of banknotes can take place in a particular series over the period, for instance, due to change in governor, year of printing, minor features, etc. Further, the volume and the value of banknotes to be printed and also its subsequent issuance in a year depends on various factors such as the expected increase in notes in circulation to meet the growing needs of the public. The need for replacing soiled, mutilated notes was to ensure that only good quality notes are in circulation. The expected increase in NIC estimate using statistical methods, which features production and supply of banknotes. The preamble mentioned, whereas so on. So, you just skip that and come to last sheet. The chronology of series is given here from 1949. So we had other series which are in circulation. So, for instance, in 1967, we had the Mahatma Gandhi Centenary Series. In 87, you added Ashoka pillar as a watermark. So, features are added. Then 96, the MG series again with the portrait and the watermark. For our purposes, in 2005 and 2016-17, the new series, the enhanced security features. So we were looking at, and the notification talked about the existing series, which means all series with a reference to denomination chosen for declaration of cessation of legal tender will be relevant for the purpose of proceeding under section 26. To say that therefore existing series was incorrect in a way of looking at it, you could have picked up a series of 96, a series of 2005, a series of 2015, would be to essentially curtail the width and the plenary width of the decision-making process on the basis of consultation between the government and the RBI. For any must mean all, and it must be as flexible as possible. Then para 2.5 at page 10. The 2016 notification has been incorporated by reference in the 2017 Act. The key argument advanced by the petitioners is that powers under section 26(2) ought to have been exercised only by the Parliament after due deliberation. In this regard, it is worth reiterating that his line of reasoning proceeds on a complete misconception about the nature of the powers exercisable under section 26(2). In fact, even a plain reading of the section, it is evident that it explicitly grants power to the executive to issue a notification for the purpose of withdrawing the legal tender status of certain banknotes, and there is no requirement for the Parliament to be involved in exercise in any manner whatsoever. As already mentioned previously, the fact that the 1946 and 78 legislation undertaken. As already mentioned previously, the fact that the 1946 and 1978 demonetization legislation were passed by the Parliament does not in any manner contradict this position, since those legislations were passed independently and not in exercise of the powers under section 26(2), a fact that is amply borne out by the presence of the non-obstante clause of section 3 of both those legislations. I'll currently invite Lord's attention to the 1946 and 19. Yeah. I'll just invite lot to the paper book. The section 3 is similarly worded, and we'll give this 78 Act. Regulations and ordinances, a small thick volume relation. That 1946, that's probably the last, third in the serial. Section 3 of the 46th Act. Separate topic. It is also there. There you are, page 4. Here it is there in that. Kindly turn that page where section 3 of the 46th Act is available. May I read it? On the expiry of the 12th day of January 1946, all high denomination banknotes shall, notwithstanding anything contained in section 26 of the Reserve Bank of India, cease to be legal tender. So it refers to section 26, notwithstanding what RBI and government can do under 26, notwithstanding that I am doing as Parliament in its plenary powers. The same provision, similar provision is in 1978 legislation. If you should now kindly come to the 2017 Act, which is also there.
That's why.
Page 10.
The 2017 Act is also in the same.
Page 10.
That's right. And in the 2017 Act, Section 3 is has taken a different form. Can I read that? On and from the appointed day, notwithstanding anything contained in the Reserve Bank, notwithstanding anything contained in the Reserve Bank of India Act 1934. Because there's a reason why it has been expressed like this. Or any other law for the time being in force, the specific banknotes which have ceased to be legal tender, in view of the notification of the Government of India so-and-so, issued under so-and-so Act, shall cease to be liabilities of the Reserve Bank under Section 34, and shall cease to have the guarantee of the central government under subsection 1 of Section 26 of the said Act. So it's a complete legislation by itself. So in the earlier situations when RBI did not give a recommendation in Section 26, there was no proceedings under Section 26. The government could have proceeded under Section 26. Parliament said, no, I am going to enact a law. So there is no deter as far as my power, plenary power of parliament. Section 23, I'm keeping aside time being, and I'm enacting a law. Here we have a situation where a section 26 power has been exercised. And the parliament takes note of the exercise of that power. It also looks into the question of whether the liability of the bank will cease, section 34 of the RBI Act. Therefore, it addresses all those connected questions. So it's not merely a question of mere talking about section 26. In the entirety of the RBI Act, if there are any issues that may come in the way of Parliament addressing this question, why Parliament has to do this? It says in view of the notification of the Government of India. Like any other legislation by incorporation and reference, you also know that. So here is a reference to a notification issued by under a statutory power. Parliament says, I'm looking at it, I've considered that. I also look at the RBI Act as a whole. So I wish that this notification receives my affirmation. And Parliament says so. Therefore, that's an important distinction between the 4678 and this law. If the story has ended only with a notification, probably would have different issues and arguments being raised before the court. The story has not ended there. Therefore, in my very humble submission, the question of going back to the notification, looking at those infirmities, if any, those false and illusory objectives you are pursuing, you can say false and illusory objective being pursued by an executive authority. Parliament, you are saying now Parliament is pursuing an illusory and false objectives. Therefore, the story does not end with the notification. It merges into the law, parliamentary law, and whatever argument that we address regarding constitutional validity will have to be addressed against the parliamentary legislation. And a very unique piece of legislation, where Parliament gives a stamp of approval to a statutory exercise of power. Paragraph 16. Page 10. Yeah. I was reading at page 11.
5.3.
Your Lordship, please, sir. Nevertheless, the submissions advanced by the petitioners carry no weight insofar as they fail to appreciate that even in the present case, the government exercise of powers so has been incorporated by reference therefore the same as effectively invalidated an act of Parliament. The notification dated 8/11/2016 has been affirmatively referred to in Section 3 of the 2017 Act. By such affirmation, Parliament can be said to have taken into account the notification and the implementation scheme. As the results in the notification were in the parliamentary law, it has ceased to exist as an independent legal instrument. It will be taken that regardless of any issues relating to the exercise of power under Section 26(2), the decision to withdraw existing series of certain denominations from legal tender must be treated as a parliamentary plenary declaration. Then, next, the exercise of power under Section 26(2) was not arbitrary and unreasonable. When judicial review, the cutoff date is not permissible. One of the grounds on which the petitioners have sought to assail the 2016 notification is that the cutoff date specified therein was arbitrary. The total period given for exchanging of banknotes was too short and many individuals suffered hardship. Why I wanted to answer this, because even though the argument that once Parliament has said all that, court need not get into the question, I thought as a matter of responding to the submission, they must be addressed and probably some clarity brought to the court. Now, next, similar arguments are regularly made in other instances where a cutoff date is specified for a particular purpose. For instance, in the case of grant of retirement benefits such as pension, receipt of applications for appointment to a position, levy of a particular rate of excise duty, eligibility for a particular scheme, etc. In all such cases, the Honorable Court has repeatedly clarified that it will not undertake a review of the date specified or hold the same to be arbitrary unless it is shown that the fixation of that particular date is capricious or whimsical or wide of the reasonable mark. In this regard, as further opined in Parameshwaran Matchworks, can we no doubt that any date chosen for the purpose would be, to a certain extent, be arbitrary, that is inevitable. The choice of a date as the basis for a classification cannot always be dubbed as arbitrary, even if no particular reason is forthcoming for the choice unless it is shown to be capricious, whimsical in the circumstances. When it is seen that a line or a point, there must be, and there is no mathematical or logical way of fixing it precisely, the decision of the legislature, the delegate, must be accepted unless we can say it's very wide of the reasonable mark. And why it says so wide of the reasonable mark? There can be cases where a doubt may arise whether the date could have been something else. But in a matter like this, one can probably visualize, I must set sail on a navigating on a river, and I do not know when I will reach my destination. I will fix a cutoff date when I know finally I've reached my destination. Therefore, I must provide for all possible permutations and combinations for people who will be affected in some way or the other, who may lose an opportunity of getting the notes exchanged or the other. Therefore, I must have all that possible 100 million permutations and computation. I mean, is it possible in a matter like that? Therefore, to ask the court to say that I went abroad, I had my dignity to be protected. Of course, millions of people traveled across the globe. He went abroad on 4th of April in 2016. He probably won't have a benefit of being an NRI. People have had the benefit of being an NRI. So you choose to have a benefit of NRI on the one hand and say, look here, my dignity is being affected. So the government must sit back and see what number of people are going abroad, whether they are NRIs, whether other Indians going for being with a family or for other purposes, and when will they come back? So how do you take this kind of a decision? Therefore, it's impossible in a matter of this national magnitude, where certainly some acts will fall somewhere. I'm not saying that the hardship is to be completely ignored. That's not an argument. Hardships will inevitably happen. I'm not closing my eyes to that at all. The government also did not close its eyes to it. Therefore, if you see from 8th of November till almost till early January, several modifications, amendments, insertions went on happening in the notification. So by the time it all got settled, the law came. The law had a clarity about at that point of time. Para 3.1.4. As such, in all instances of fixation of a particular date, it stands to reason there will be persons on both sides of the said line, and those who are left out will be agreed by their exclusion. As long as the exclusion is not deliberate or discriminatory, the court will not test the validity of a cut date. Cut-off date cannot be altered, modified, or extended to accommodate all possible exclusions. Administrative decisions based on the larger public interest or public convenience will not be altered on the basis of the interest of some person or an inchoate class of them. A similar argument raised in the context of the high denomination banknotes was struck down by a 5-judge bench honorable court holding. It is however contended on behalf of the petitioner that even if it is assumed that Article 31 cannot be violated, the time prescribed for exchange of the high denomination banknotes in Section 7 and 8 of the Demonetization Act is unreasonable and violates the fundamental rights. When the above provisions of the Act are considered in the context of the purpose of the Demonetization Act sought to achieve, namely to stop circulation of high denomination banknotes as early as possible, the above contention of the petitioners cannot be accepted. Consequent upon the high denomination banknotes ceasing to be legal tender on the expiry of January 16, 1978, and in view of the prohibition in the transfer of possession of such notes from one person to another, thereafter the envisaged in Section 4, it is absolutely necessary to ensure that no opportunity was available to the holders of high denomination banknotes to transfer the same to the possession of others. At the same time, it was necessary to afford a reasonable opportunity to the holders of such notes to get the same exchange. However, if the time for such exchange was not limited, the high denomination banknotes could be circulated and transferred without the knowledge of the authorities concerned from one person to another, and any such transferee could walk into the bank on any day thereafter and demand exchange of his notes. In that case, it would have been well nigh impossible for the bank to prove that such a person was not the owner or holder of the notes on January 16, 1978. That's the question which will confront the bank, the RBI, under Section 4.2. Needless to say, in such an eventuality, the very object in the Demonetization Act sought to achieve would have been defeated. Obviously, to strike a balance between these competing and disparate consideration that Section 7(2) of the Demonetization Act limited the time to exchange the notes till January 19, 1978. However, even thereafter, in view of Section 8, the high denomination banknotes could be exchanged from so-and-so, provided the tenderer was able to explain the reasons for his failure to apply for the exchange within the time stipulated in Section 2 of the Act. Such being the scheme of the Act regarding exchange of high denomination banknotes, cannot be said that the time and the manner in which the high denomination banknotes could be exchanged were unreasonable, unjust, and violative of the petitioner's fundamental rights. I say with all my humility that the Constitution, when correctly understood, that the flexibility required cannot be brought within any parameters. That's why I kept on saying it cannot be cribbed, capped, and confined. Next, the test of proportionality cannot be pressed into service. The proportionality test is essentially the test of reasonable. The means adopted for the implementation of the decision must be means relevant for the object sought to be achieved. The relevance of the means will be dictated by the nature of the object to be achieved. It may not always be the case that the object can be achieved by more than one set of means. In the instant case, currency management is the object that the RBI will always continue to pursue and handle. Issuance of banknotes as legal tender and declaration of banknotes ceasing to be legal tender only means conceived under Section 26 for the purpose of currency management. Choice of means, therefore, does not arise. The reliance in so-and-so case for the purpose of invoking proportionality is misconceived. On the issue of challenge to the mandatory linking of bank accounts with Aadhaar, what was found objectionable was the presumption of criminality targeting every citizen of the country. And therefore, there cannot be a mandatory provision for linking of every bank account with Aadhaar for the purpose of checking the possible malice of money laundering. In the instant case, the choice of denomination was dictated by reason of the fact that the two denominations chosen are the largest denominations in circulation and are the ones which are involved vis-a-vis black money, fake currency, and terror financing. The question of identifying currency involved above three does not arise. It would be conceptually wrong to suggest that if there are difficulties in such identification, then Section 26 should not be pressed into service at all. The fourfold test involved in proportionality cannot therefore be logically pressed into service. Let me try to answer each one of them. The fourfold test is answered as under. First test is designated for a proper purpose. Answer. Currency management and monetary policy will always remain a designated purpose of high importance. All means and measures that may be found necessary from time to time to ensure the integrity and stability of currency management will also remain a purpose of importance. There can be hardly any debate on the importance of the purpose which is legitimately enacted in the scheme of the RBI Act 1934. Then, 2. Measures are undertaken to effectuate that the limitation are racially connected to the fulfillment of the purpose. Answer. Declaration of banknotes as legal tender and their cessation, which should not be, and their cessation as legal tender are the means designed to handle the currency management. It cannot be said currency management can be handled through other measures or without the principle of banknotes as legal tender. Additionally, the question is not one of imposing any limitation on the currency management, nor of effectuating the limitation. The limitation issue comes in when rights are sought to be infringed. There is no question of limitation of the powers of the RBI at all. Now, 3. There are no alternative, less invasive measures. The 3 evils sought to be addressed, namely black money, fake currency, and terror finance, breed on paper currencies, precisely because the paper currencies of certain denominations are conducive to aid such activities. The question as to whether government should explore non-currency management measures as better or wise choices for the purpose of addressing these evils is not a matter for the court, nor a subject of judicial review. The government is duty-bound to address these evils, if necessary, by resort to currency management purpose and the tool of Section 26(2). 4. There is a proper relation between the importance of achieving the aim and the importance of limiting the right. This limb of the test, when it involves commensurating incommensurables, that is comparing unequals, commensurating incommensurables, it will break down. The importance of addressing the three evils referred to above cannot be compared with the importance of causing least impact on the use of legal tender. If the government were to search for the magic measures of causing least impact and wait till such time, the object of addressing these evils can possibly never be undertaken. Since legal tender, cessation of legal tender, paper currency, currency management, exploitation and abuse of legal tender are all inextricably linked, and there is hardly any room for applying the above limb of the test with carefully chosen precision and degree. The wide range of instances involving application of the fourfold test of proportionality or otherwise will demonstrate that either within the statutory framework or within the scope of possible legal means for achieving a purpose, there has been misconceptions or failures as regards the means chosen, the extent of the sweep of the means chosen, or the failure to redress the impact of the means chosen means. It is submitted, we are talking about 86.4%, repeatedly is being fought about. So it is submitted that the suggestion for adoption of proportionality without rigorous scrutiny of its application can lead to open-ended moral or political reasoning, and the persuasion to engage in open-ended moral or political reasoning will always be avoided. Courts are conscious of the fact that the complexity of economic regulation always involves dealing with complex set of factors, the scope for error, experimentation, conflict of opinions among experts, and other similar factors. And therefore, courts grant the legislature and the executive greater latitude and play in the joint in matters necessarily involving interplay between principles, facts, and policy. So Section 26, this law, this notification is an example of interplay between principle, facts, and policy. 3.2.7. Accordingly, judicial review of economic policy ought to be restricted to the nexus test wherein the court may only determine if there is a rational nexus with the object sought to be achieved. That is, determine the relationship of the means to that is, determine the relationship of the means to end. Any other test, including the proportionality test, would impinge on the freedom of the executive and the legislature in enacting and implementing economic policy measures. Going any further would also dilute the well-established and oft-repeated universal position of law that courts ought not to engage in judicial review economic policy legislation in promotion of economic measures. I'll place the two judgments for Lord's consideration. One, a recent judgment where the distinction between non-classificatory discrimination and classificatory discrimination arbitrariness. I'll just place it in a few minutes. Now let me complete the reading of this. The notification dated 16/12/2016 has been conceived as a first step measure towards addressing the three evils and to lay the foundation for further scope for addressing those evils as well as achieving major milestones of larger economic transformatory and reformatory process that has been going on since the year 2014, probably even earlier. The aforesaid economic reformatory process includes the strengthening and expansion of the formal sector with the simultaneous reduction of the informal sector through the means of digitization of transaction, technology connectivity, increasing the tax base, enhancing tax compliance, lowering the cost of doing business, eliminating policy distortions, facilitating financial inclusion at the formal sector level in labor and agrarian reforms. A whole lot of them. In view of the above stated larger purpose, the legitimate aim and objective of demonetization as here. As one amongst other monetary and economic policy decisions cannot be subject to judicial review on the grounds suggested by the petitioners. May I just quickly, at this point of time, you'll also take to the cryptocurrency judgment and one second, just one second. I'll check. This is the 2020-10 SEC 274. at page 322, paragraph 70, Lordships had occasion to look into the addition to the preamble, which I read out, which I'll read out again. So after looking at the important additions in the preamble, on the right-hand side, we have those two important additions. And whereas it is essential to have a modern monetary policy framework to meet the challenge of an increasingly complex economy, and whereas the primary objective of the monetary policy is to maintain price stability while keeping in mind the objective of growth, and whereas the monetary policy framework in India will be operated by the Reserve Bank of India. And then kindly turn to para 72. Therefore, it's clear that after the amendment under 2016, the very task of operating the monetary policy framework has been conferred exclusively upon RBI. Then at paragraph 85, at page 326, where the court also notices the Banking Regulation Act. The RBI Act is not the only act when the RBI derives its powers. Banking Regulation Act is also a source of power for RBI to do certain things. This can be seen from the statement of objects and reasons for the banking regulation. One of the main features of the bill, as indicated in the statement of objects, was widening the powers of RBI as to enable it to come to the aid of banking companies in times of emergency. That's another being of the RBI functions. Then kindly turn over to paragraph 117. The context of money, history, what is legal tender, etc. The court traces beautifully those history of money. And page that the 1879 definition cannot be accepted as perfect, final, and everlasting in modern times. Cross-border transactions and technological advancements have removed many shackles created by old concepts. This fact has been recognized in the dissent of so-and-so. When he says, what we view as money has changed over time. Cowrie shells once were such a medium, but no longer are. Currency originally included gold, coins, and bullion. But after 34, gold could not be used as a medium of exchange. Perhaps one day employees will be paid in Bitcoin or some other type of currency. The English linguistic sense, English Oxford Dictionary, has already indicated property or possessions of any kind viewed as convertible into money within definition of money and all that. Then, therefore, Breyer J. points out his dissent. So where does this duel of definitions lead us? Some seem too narrow, some seem too broad, some seem indeterminate. The result is ambiguity. He therefore concluded the stock options given to employers constitute money remuneration for the service rendered, but the majority pressed in the base that when the law was enacted, the term money was not used in expansive sense. So we are looking at what possible sense a word can receive given the context in which the statute wishes to operate. Then 118, the middle of that, even though it's again in the context of cryptocurrency, just after placitum B, or para 118, clause 33 of section 65B of the Finance Act, inserted by way of Finance Act, defines money to mean legal tender, check, promissory note, bill of exchange, letter of credit, so on and so on and so forth. This definition is important, but it identifies many instruments other than legal tender, which come with the definition of money. Therefore, we are at an age when not only legal tender, something which can claim to be a legal tender, how do you go about regulating it? This court answers this case in this case. I'll presently point out how the reference to proportionality was context specific and cannot be probably invoked as far as this particular case is concerned. Now, kindly pick up paragraph 137. Because the court notices what happened in the case would. Your Lordship, may kindly turn to para 141 at page 359.
Para?
141. pointed out elsewhere, RBI is the sole repository of power of the management of the currency under Section 3. RBI is also vested with the sole right to issue banknotes and to issue currency notes supplied by the government of India, and an important role to play in evolving the monetary policy of the country. By participation in the Monetary Policy Committee, which is empowered to determine the policy rate required to change the inflation target in terms of the Consumer Price Index. Therefore, anything that may pose a threat or to have an impact on the financial system of the country can be regulated or prohibited by RBI, despite the said activity not forming part of the credit system or payment system. Therefore, even if it's not part of a payment system or credit system, RBI will certainly extend its hands to deal with that. But what to say of terror financing, black money, and fake currencies? And as I said, they're all. The expression management of the currency appearance also need not necessarily be confined to the management of what is recognized in law to be currency, but also we include capable of faking or playing the role of a currency. And at page para 150 at page 363, law is well settled when RBI exercises the powers conferred upon it, both to frame policy and to issue directions for the enforcement. Such directions become supplemental to the Act itself. In PLR so-and-so, court followed the decisions in state of UP with Baburam Upadhyaya and DVK so-and-so to hold the rules made under the statute will be treated as if they were contained in the Act, and therefore they must be governed by the same principle as the statute itself. Useful reference can also be in regard to the following observations so and so. When a delegate is empowered by Parliament to enact a policy and to issue direction, which have a statutory force, and when the delegate issues such guidelines having statutory force, such guidelines have got to be read as supplement to the provisions of the Banking Regulation 1949. The banking policy is initiated by RBI. Such policy cannot be said to be ultra vires the Act. At paragraph 177 at page 371, before the court turns over to the proportionality test.
Can read the next para also.
I'll come to that.
Para 151.
Para 151. In his treatise on administrative law, I go back to page 363, paragraph 151. In his treatise on administrative law, Durgadas Basu states the scope of judicial review is narrowed down when a statute confers discretionary power upon executive authority to make such rules or regulations or orders as appear to him to be necessary or expedient for carrying out the purpose of the statute or any other specific purpose. In such a case, the check of ultra vires vanishes for all practical purposes, inasmuch as the determination of the necessity or expediency is taken out of the hands of the courts, and the only ground upon which the courts may interfere is that the authority acted malafide or never applied his mind to the matter or applied an irrelevant principle in making a statutory order. I go down to your lordship's that's so on the larger usual administrative law challenge, relevant grounds, irrelevant factors taken into account. So the petitioners want your lordships to go into the question as to whether 86.4 currency notes and the hardship that will be caused by increasing all those notes in one go. So you're not applied it mind, the relevant factor to be applied to your mind. So you must have a study how it will impact. I'll presently show that for more than a decade, governments and RBI have been looking at these three twin problems. The 1978 legislation was also addressed this question. Therefore, if the nation is called upon to address this question in very complex, dynamic, globalized situation, and where all the three factors can mask themselves, cover themselves under any facades, and escape any inquiry, and you will still say address each one of these questions by an open debate, share them with the citizens of the country, and say, tomorrow I'm going to take a decision on this. Therefore, all these three evils, which I kept on saying last time, which grin at you from somewhere in the corner where you cannot even reach. All those measures taken over a large period of time. Black money is stashed elsewhere. You can say they fail. Therefore, you should not touch them. It's like Jarasan. Unless you know how to kill Jarasan, you must cut him into pieces. If you don't cut him into pieces, Jarasan will always be alive. Therefore, it's a very hot choice. Like a choice.
Not cutting two pieces, cutting two pieces and throw it.
And throw it. Asunder. Take asunder. That's how it's happened.
It doesn't join.
Otherwise, it will join. Join. So we are looking at a phenomena which is a big challenge to the state. Not only here, elsewhere. Paragraph 177 at page 371. The impugned circular cannot be assailed on the basis of MS skill test for two reasons that the Mohinder Singh statement in the election matter. First is that the All India Railway Recruitment Board, so and so, this court held that MS guild test may not always be applicable where larger public interest is involved, and that in such situation, additional grounds can be looked into for examining the validity of an order. This followed in so and so, this court clarified that there is no broad proposition that MS skill test will not apply and the larger public interest is involved. Subsequent material in the form of facts that have taken place after the order in question is passed can always be looked at in the larger public interest in order to support an administrative order. That's why it took time to show lodges from 2016 onwards. What are the developments that have taken place? Directly or indirectly, tangible or intangible. If you want to look at this case only from the midnight of 8th of November 2016, the case is very different. The second reason why the weapon of MS Gill will get blunted in this case is that during the pendency of this case, the court passed an interim order, let's skip that. Then come to paragraph 178, where the court is getting into the proportionality test. The next argument is the impugned measure is extreme and it will not pass the test of proportionality. For the purpose of convenience, we'll take the argument together. The arguments revolving around Article 19(1)(g) will deal with the reasonableness of the restriction. For our purposes, I think it's sufficient if your lordship kindly turn to page 1, paragraph 190 at page 374. Why the court went into the question of proportionality in the context of a particular case. The court is again giving an overview of the role of RBI, paragraph 190 at page 374. But given the scheme of the RBI Act 1934 and the Banking Regulation Act 49, there were argument appears only to belittle the role of RBI. RBI is not just like any other statutory body, act of legislature, created with a mandate to get liberated even from the creator. That's why it's given a mandate under the preamble of the act to operate the currency and credit system of the country to its advantage and to operate the monetary policy framework in the country under section 3(1) to take over the management of the currency from the central government, section 20 to undertake accept monies for account of the central government, to make payments up to the amount standing to the credit of the account, and to carry out the exchange, remittance, and other banking operation, including the management of the public debt of the union. Under section 21(1), to all the money, remittance, exchange, and banking transactions in India of the central government interests so and so. 5. Under section 22(1), they have the sole right to issue banknotes in India. 6. In section 38, to get rupees into circulation, only through it, to the exclude central government. Therefore, RBI cannot be equated to any other statutory body that merely serves its master. It's specifically empowered to do certain things to the exclusion of even the central government. Therefore, to place a decision that a pedestal lower than the executive decision would do violence to the scheme of the Act. That's the largest scheme of the RBI Act. I just want to juxtapose how do you really apply this principle in the context of section 26. This section 26 is the important, the spine of the whole legislation. So if in that context, you want to apply narrow principles of looking at it, you will get one set of consequences. You want to look at it from a broader perspective, the role RBI and the government acting together on a consultative basis, and without playing fetters on how the consultation should take place, then you get yet another consequence. a consequence or an result which will serve the purpose of the RBI Act and handling of monetary policy and currency management, and the role of the government in ensuring that the monetary stability of the country is safeguarded and ensured. And that's how the court goes into the question of the importance of RBI from a wide range of perspectives. Now, kindly turn to paragraph 192. Again, the same proposition is restated. Important for the purpose of the first few lines. Pointed about RBI is not just any statutory. It's not like a stream which cannot be greater than the source. If the pre-constitutional legislation survived the Constitution by virtue of Article 372, the difference between other statutory creatures than RBI is that whether statutory creatures can do and could do as will be done by the executive, the power conferred, delegated in some other statutes, can be tinkered with, amended, or even withdrawn, the power conferred and so 3.1 to take over the management of the currency in the central government cannot be taken away. Now, paragraph 197. May read para 193 so that the context of 194 is understood. 193 at page 376. The next ground of attack is on the basis of Article 19(1)(g). Any restriction to the freedom guaranteed in the Article 19(1)(g) should pass the test of reasonableness in terms of 19(6). Contend with the petitioner that since access to banking is equivalent or the supply of oxygen in a modern economy, the denial of such access to those who carry on a trade which is not prohibited by law is not a reasonable restriction, and that it is also extremely disproportionate. It's further contended that the right to access the banking system is actually integral to the right to carry on any trade or profession, and therefore a legislation, subordinate or otherwise, whose effect or impact severely impair the right to carry on a trade or business not prohibited by law would be violative of Article 19(1)(g). Reliance is placed in regard and decisions court in Muhammad Yasin with the Town Area Committee, where it was held the right in Article 19(1)(g) is affected. In effect and in substance, the impugn measures brought about a total stoppage of business, both in a commercial sense and from practical point of view, even though there is no prohibition in form and to Bennett Coleman Union of India. This court held that the impact, not the object of the measure, will determine whether or not a fundamental right is violated. It's further contended the strength of the decision Muhammad Farooq that the imposition of restriction on the exercise of fundamental right may be in the form of control or prohibition, and that when the exercise of a fundamental right is prohibited, the burden of proving that a total ban on the exercise of the right alone may ensure the maintenance of the general public interest lies heavily upon the state. It was held in a said decision that a law which directly infringes that the rights guaranteed in Article 19(1)(g) be upheld only if it is established that it seeks to impose reasonable restrictions in the interest of the general public, and a less drastic restriction will not ensure the interest of the general public. That's the test which ought to be applied here. The parameters laid out in Muhammad Farooq were unimpeachable. While testing the validity of a law imposing restrictions on the carrying on a business or a profession, the court must have formulated Muhammad Farooq attempt an evaluation of its direct and immediate impact upon the fundamental rights of citizens affected thereby, the larger public interest sought to be ensured in the light of the objects sought to be achieved, the necessity to restrict citizens' freedom, the inherent pernicious nature of the act prohibited, or its capacity or tendency to be harmful to the general public, and the possibility of achieving the same object by imposing a less drastic restraint. There are two questions to be addressed here, just to digress for a minute. If the government and RBI has to take a decision on addressing those three evils, then you will have to apply your mind. Look at the volume of circulation of notes of 500 and 1,000. How are we going to impose so many restrictions and hardships on the general public? Should the government or the decision-making authority keep aside all these considerations, not only look at the evils sought to be addressed, or close his mind to the evils sought to be addressed and only look at them? Therefore, the balance which have to be achieved will be the real test in a matter of this nature. To say that hardships have been completely, not adverted to, we're probably taking it to an excessive length. the occurrence of certain series of events in the course of exchange of notes may be unfolding events of hardships. But to say that in order that we'll have a period during which people will be able to enable to exchange their notes, and it will be a longer period, shorter period, and whatever consideration may come for the purpose of facilitating them, then I'm only addressing a very different, narrow issue about the whole issue of addressing the other three evils. So that's why I said you are talking about comparing the incommensurables. The two are not comparable at all. That's why in a proportionality test, I'll place before your lordships a very interesting reading from Hook on critique of proportionality and balancing, which says very often in a proportionality test, incommensurables are compared. And there's always a scope for unrestrained moral reasoning, not for wrong reason. The court is always prompted to get in some moral reasoning, sometimes for good reasons. Let me read further. Paragraph 190, 197.
95, so not reading. Okay. You're not reading 195.
Paragraph 197 at page 378.
Mr. Chidambara wants you to read 195 also.
I'll read it. I'll read it after I finish
He
reading.
wants to read it. You to read it. Very well.
I will read it in a context.
Okay.
Para 197. The second objection of RBI is there is no fundamental right to purchase, sell, transact, or invest in virtual currencies, and that therefore the petitioners cannot invoke Article 19(1)(g). But his contention is liable to be rejected outright for two reasons: that at least some of the petitioners are not claiming any right to purchase, sell, or transact in virtual currencies, but claiming a right to provide a platform for facilitating an activity of trading in virtual currencies between individuals, entities who want to buy and sell VCs, which is not yet prohibited by law. And that in any case, the impugned circular does not per se prohibit the purchase or sale of virtual currencies. This is why it is contended, then accounts for the petitioner, that what is hit by the impugned circular is not the actual target. So that was one important reason why the court went into the proportionality test in this case. The object of hitting at trading in VC is to ensure that, just after Placitum C, the object of hitting at trading in VCs is to ensure consumer protection, prevention of violation of money laundering laws, curbing the menace of financing terrorism, and safeguarding of the existing monetary payment credit system from being polluted. But hitting the target directly is not within the domain of RBI, and hence the impugned circular purportedly seeks to protect only those regulated entities by ring-fencing them. In the process, it has hit VC exchanges and not the actual trading of VCs, though as a consequence, the volume of transactions in VCs is stated to have come down. People who wish to buy and sell virtual currencies can still so merrily without using the medium of the VC exchange and without seeking to convert the virtual currencies into fiat currency. It is in this context, contention of revolving around 19(1)(g) has to be examined. Then at page paragraph 198, let me read that. In order to test the validity of the impugned action and the touchstone of Article 19(1)(g), you may have to understand the fundamental distinction between the purchase and sale of virtual currencies by and between two individuals or entities and the business of online exchanges that provide certain services such as the facility of buying and selling virtual currencies, the storing or securing of virtual currencies, what are known as wallets, and the conversion of virtual currencies into fiat currency and vice versa. The buying and selling of cryptocurrencies through VC exchanges can be by way of hobby or as a trade or a business. The distinction between the two is that there may or may not exist a profit motive in the former, while it would be in the later. Then then talk about the category of persons who may engage in virtual currencies. Kindly turn over to paragraph 206 at page 380. And just about that, paragraph 205, persons who have suffered a deadly blow from the impugned circular are only those running virtual exchanges, not even those who are trading in VCs. Persons trading in VCs even now have different options, some of which we have discussed above, but the VC exchanges do not appear to have found any other means of survival, if, at least as of now, they are disconnected from the banking channel. In all cases, where legislative executive action infringing the right guaranteed in Article 19(1)(g) were set at naught by this court. This court was concerned with a ban or prohibition of an activity. The question of the prohibited banned activities having the potential to destabilize an existing system did not arise in those cases. The pleadings contained the first writ petition from so-and-so would show the three companies who are members of the Internet Mobile Association had combined total of approximately 17 lakh verified users throughout India. These companies held a combined total of approximately 1,365 crores of user funds in trust. The approximate monthly transactions for just these three companies around 5,000 crores. Even according to the petitioner, the crypto asset industry is estimated to have a market capitalization of approximately $430 billion globally. India is estimated to contribute 2 to 110% based on various estimates. Admitted that the total number of investors was approximately 20 lakh and the average daily trade volume was at least 150 crores at the time when the writ petition was filed. Therefore, if a central authority like RBI on a conspectus of various factors perceives the trend as a growth of a parallel economy and sever the umbilical cord that virtual currency has with the fiat currency, the same cannot be very lightly nullified as amending Article 19(1)(g). But nevertheless, then kindly come to, then the court goes into how the targets have been wrongly picked up, and therefore the question of proportionality. Finally, at page 230, paragraph 234. In para 224, as I said, the reasons for entering into the proportional test and the conclusions drawn. It's no doubt true that RBI has very wide powers, not only in view of the statutory scheme of the three enactments indicated earlier, but also in view of the special place and role in the economy of the country. These powers can be exercised both in form of preventive as well as curative measures. But the availability of power different the manner and extent which it can be exercised. And that's while we have recognized elsewhere in this order the power of RBI to take a preemptive action, we are testing in this part of the order the proportionality of such measure, for the determination of which RBI needs to show at least some semblance of any damage suffered by its regulated entities. But there is none. And the consistent stand of RBI is that they have not banned VCs. The government of India is unable to take a call despite several committees coming up with several proposals, including the two draft bill, both of which advocated exactly opposite positions. It's not possible for us to hold that the impugn measure is proportionate. So for that's the factual matrix in which the court was persuaded to enter into a proportionate analysis. And the court is conscious of the fact that having traced the extent and sweep of the powers of RBI, it's an important role as a monetary policy, framing and executing authority. Not in all cases, the court will probably enter into this proportionality test. But it's one of those narrow circumstances when, in an economic policy measure, when not necessarily an economic policy measure, but acting, exercise your powers under the act. Oh. This judgment I want to place for Lordship's consideration on an important distinction the court has recently drawn. Paragraph 2, that's how the question arose. The government of Tamil Nadu granted a waiver of outstanding crop loans, medium-term agricultural loans, long-term farm sector loans issued to small and marginal farmers. So-and-so was issued providing guidelines for the implementation of due so-and-so. Guidelines provide that for the classification of farmers as small and marginal, the extent of land holding is mentioned in the land holding register and loan register. At the time of sanction of the agricultural loan should be taken into consideration. As for the definition of small farmer and marginal farmer, it provides so-and-so. All that issues of fact. And sought a direction to provide loan waiver for all farmers irrespective of the extent of land holding. The High Court allowed the writ petition holding that the exclusion of other farmers, those who hold land exceeding 5 acres from the land waiver scheme, is discriminatory and violative of Article 14. It directed the scheme be extended to all farmers, including farmers whose land holding exceeds 5 acres. The High Court is aided by the following reason to arrive at this conclusion. Courts can exercise judicial review in the realm of policy to determine if it conforms to the requirements of Article 14 of the Constitution, held by this court in Union of India, so-and-so, then made an electoral promise to implement the scheme he voted to power. The counter filed with the response stated that small and marginal farmers constitute a class in themselves, and they require more assistance because of their meager income resources. There is no indication of the reasoning in the file. ADMK introduced the scheme after being voted to power in pursuance of election promise, without taking into consideration relevant factors warranting such a classification. The contention of the state that the objective of the scheme is to cover a maximum number of beneficiaries with a minimum outlay of funds cannot be accepted. And the overall objective of the government is to obviate the suffering of the farmers. Classification based on the extent of holding is not intelligible. Farmers who apply for agricultural loan are not required to disclose all their land holding. Question 1. The court can exercise its powers of judicial review. The scheme is a policy decision of the government. The extension of the scheme only to small farmers and marginal farmers is arbitrary and violative of Article 14, and whether the scheme is under-inclusive and over-inclusive. I will not trouble your lordships with the details of this reasoning process. In paragraph 10, all those cautions are restated. The court cannot, paragraph 10, cannot interfere with the soundness and wisdom of policy on the limited grounds of compliance with the fundamental rights and other provisions of the Constitution. Also settled courts which show a high degree of deference to matters concerning economic policy compared to other matters of civil and political rights. In R.K. Garg, this court decided on the constitutional validity of the special bearer bond. The challenge to the statute on the principal ground is violative of Article 14. Rejecting the challenge, the Constitutional bench observed laws relating to economic activities must be used greater latitude and deference when compared to laws relating to civil rights such as freedom of speech. Then I'll take your lordship that Balfour is considered. Your lords kindly turn to paragraph 27 of the judgment on one of the issues posed by the court about under-inclusion and over-inclusion. Just make a note of that. That's how the court goes into the question whether the classification can be tested on this ground. In paragraph 29, the determination of whether the classification is under-inclusive is closely related to the test that is undertaken by the court while determining the relationship of the means to the end. The court follows the two-pronged test to determine if there is been violation of Article 14. The test requires the court determine if there is a national nexus with the object sought to be achieved. So-and-so in Rayappa held the arbitrariness of state action is sufficient to constitute a violation of Article 14. Thus, it came to be recognized that the equality doctrine is envisaged in the Constitution not only guarantees against comparative unreasonableness, but also non-comparative unreasonableness. The court in Modern Dental College, so-and-so, invoked the proportional test while testing the validity of the statute. and rules that sought to regulate admissions, fees, and provided reservations for postgraduate courses in private educational institutions. In Subramaniam Swamy, the court used a proportional test to determine if the offence of criminal defamation prescribed in Section 499, 500, violates the freedom of speech and expression in Section 19(1). In Puttaswamy, a 9-judge bench of the court held the right to privacy is a fundamental right. The proportional test was used in the context of determining the limits that could be imposed on the right to privacy. The Constitution then dealt with the proportional test in justice so-and-so, determining the Aadhaar scheme violates the right to privacy of an individual. Our courts have used the proportionality test standard to determine non-classificatory arbitrariness and have used the twin test to determine the classification is arbitrary. As long as the classification test is to be applied, proportional test will not. Okay. So the non-classification arbitrary question will come under proportionality, umbrella. Paragraph 32. While non-classification arbitrariness is tested based on the proportionality test, but the means are required to be proportional to the object, classification arbitrariness is tested in the racial nexus test, where it is sufficient if the means share a nexus with the object. The degree of proof and the test will impact the judgment of the court and whether the law is under-inclusive or over-inclusive. A statute is under-inclusive if it fails to regulate all actors who are part of the problem. It is over-inclusive if it regulates actors who are not part of a problem the statute seeks to address. The determination of under-inclusiveness and over-inclusiveness and degrees of difference depend upon relationship prong of the test. Then the nexus test, unlike the proportionality test, is not tailored to narrow down the means to find the best means to achieve the object. It's sufficient if the means have a racial nexus to the object. Therefore, the court show a greater degree of deference to cases where the racial nexus is applied. A greater degree of deference is shown the classification because the legislature can classify based on the degrees of harm to further the principle of substantive equality, and the classification does not require mathematical precision. The Indian courts do not apply the proportionality standard to classificatory provision. So the two-judge bench articulated the proportional standard for the protective discrimination on the ground of Article 15, and Justice Malhotra held that less difference will be allowed when the classification is based on the innate and core trait of an individual. This is not the case with Delvin Reed. In the classification, the impugned scheme is based neither on the grounds of Article 14 nor on the innate and core individual. It cannot be struck down on the other grounds of under-inclusion or over-inclusion. So the court cuts down this case. For our purposes, what I want to say is that in the difference between a non-classification arbitrariness, which is part of proportionality, and the classification arbitrariness will have to be very clearly kept in mind.
We'll continue at 2.
Your Lordship.
legal permission, my lord.
Yes.
My serial number is 21, my lord. Exhibition is filed against me, my lord. And in Salford, DOJ, my lord.
Which is your list?
My lord is totally right. If my ordinary letter is here, my lord, is serial number 21. If this letter will not be taken, my lord, otherwise my.
All right, you must make a submission before the appropriate bench, not before this. Wait.
If kindly can,
All right, wait,
kindly
please.
can help me, my lord.
All right, please wait.
I was reading that state of Tamil Nadu judgment. Before I go further, I was trying to refer to the judgment for this purpose. A non-classificatory arbitrariness and a classificatory arbitrariness. There was a non-classificatory arbitrariness, proportional test will come in. This classificatory arbitrariness, the nexus test will come in. So my submission is, this is not a case where a non-classificatory arbitrariness test will be applied because the factors are different where it can be applied. There will be a case only a classificatory arbitrary test that the nexus test will be applied. And if you apply that test, this case passed through the test.
Please repeat, Attorney. Sorry.
Your Lordship,
Attorney General.
kindly turn to page.
What did you say? What did you say? Just please.
Kindly turn to paragraph 32 of the judgment. I'll read. There are two in the context of a classificatory test. Classification being challenged as unconstitutional. We look about the nexus between the object and the means. That's the nexus test. In the case where it is not a classificatory arbitrariness, but a non-classificatory arbitrariness, proportional test will come in. That is what the judgment tries to talk about. Therefore, that the test will be entirely different. My submission is, it is only a case of a classificatory arbitrariness, if at all. And the test to be applied is only the nexus between the means and the objects ought to be achieved. Therefore, this is not a case where a proportionality principle will come in on all its force for the purpose of entering into the merits of the policy decision taken by the government. So the merits of the decision taken by the government, you always know, in administrative law, we talk about the means of the processes, the process, legality of the process, and the legality of the merits. So proportionality sometimes enters into the legality of the merits. That is where the non-classificatory arbitrariness involved in a decision taken is sought to be put to test before the proportionality test. This judgment says the two are distinct, and I'm only trying to advance the distinction between these two. And our case would fall within the classificatory arbitrariness, if at all. The test to be applied is the nexus test. Now, I said so in my paragraph 3.2.7. Before I proceed further with some important aspects, let me try to answer a query Raghunathan put to me before the forenoon. I could eventually trying to collect any parallel where a recommendation process would be involved. I thought of this example, which may probably throw some light. Under the Indian Medical Council Act, we have a medical council. Earlier, state governments used to give approvals or permissions for medical colleges. After 10 years was introduced, it became the central government. The medical council is the person, authority concerned, who will give a recommendation to the central government.
Under the old act.
That's right. So the recommendations, then the central government also enters into the fact situation. You may accept the recommendation or may not accept the recommendation.
Not binding on the state.
Exactly. There, the medical council acts as an entirely independent statutory authority with no consultative process on an everyday basis with the central government. No. Here, the position is entirely different. As I would point out from a speech made in Parliament in 2005, when the 2005 RBI amendment.
Recommendations are never bound.
A
decision-making authority, the only question would be whether the decision-making authority has considered the recommendations in proper perspective or not.
That's right. I only want for the line of demarcation where the Council Act. Ten capital A.
Yes.
Notwithstanding anything contained so and so, no person shall establish a medical college and all that. It says, except with the previous permission of the central government obtained in accordance with the provisions of this section. Then it says, every person in subsection 2, every person in a medical college for the purpose of obtaining permission, submit to the central government a scheme in accordance with the provisions of clause B, and the central government shall refer the scheme to the council for its recommendations. Then subsection 3 talks about the council considering those particulars. In subsection 4, it says the central government may, after considering the scheme and the recommendations of the council and after obtaining where necessary, etc., give a permission or decline a permission. Therefore, that kind of a recommendation setting, statutory setting, is different from a statutory setting like 26 days. Okay, I thought there is some clarity is possible. Now, give me this book. I'll make a copy of the speech made in 2005 amendment bill of the RBI was introduced. I'll just make a copy of it and give it to your lordships in a short while. You may read it for the lordships kind consideration very slowly. The banking system is expected to grow and will grow at a very fast rate to keep pace with the growth of the economy. We therefore need regulators with adequate powers and with considerable degree of autonomy to act quickly. The RBI is one such regulator. It has served this country very well. It has a very high reputation among central bankers all over the world. In India, we have the RBI, we have the SEBI, we have the insurance regulator. Even though we do not have a super regulator, there is a high-level committee consisting of the governor of RBI, the chairman of SEBI, the chairman of IRDA, and the Secretary Department of Economic Affairs, Ministry of Finance, which meets periodically, exchanges the information and coordinates policy making. With the powers that we are now giving to the RBI, I think RBI will arm greater authority and autonomy to deal effectively with the subjects that have been given to you in the RBI Act. I'll make a copy of it and place the order. Now let me proceed to read.
I don't know who was the honorable minister at that time.
We're at 3.2.7.
That speech was that was as an honorable minister, not as now he is here as a council.
With the greatest of respect.
So Leonard AG, I think is trying to say is that the minister did not have proper legal advice.
Or possibly trying to show the mirror.
I would seriously contest this proposition probably in a different forum. But I would like to just keep it. May complete reading of my notes and share your lordships with your lordships a few documents and taking your lordships back to the 1978 parliamentary debates and say we throw some light on why the government was urged in those days when 500 and 1,000 rupee notes were sought to be demonetized. Parliamentary debate said, why are you leaving 100 rupee notes? If you don't touch it, and you are not really touching the life of a demonetization issue. I'll presently place those debates in Parliament. Para 3.2.7 at page 16 of my.
In 78, was there any directly act was made or?
Yes, directly. Direct. That's why
there is no ordinance.
No.
78.
Ordinance was there. 1970.
Ordinance followed by act.
Ordinance immediately followed by.
Followed by act.
So Sundaresan.
Yes.
Janaki Raman.
Janaki Raman and Sundaresan. They drafted it.
Janaki Raman.
Okay, all right.
The speed which this was done.
They were RBI. They were some.
with the dynamics of policy making in our country.
I could not speak to RBI about that also.
It was not under 26.
Lordship, sorry.
Notwithstanding.
May-
Notwithstanding.
We really don't know how these things are. Only Mr. Chidambaram has to explain to us all these dynamics. Sometimes we don't know their compulsions.
Not only that.
The Honorable Court keeps a distinction between what was done in 46 and 78. There is one power, and what is done in 2016 is a very different power. That was plenary legislation by Parliament. This is under the RBI Act by the executive government. Kindly keep that distinction in mind, my lord. Most of these arguments will fall in place.
May I come back to my paragraph 3.2.7 in page 16?
Yes.
You already come to, you finished 3.2.10.
I'm sorry, yes, sir, page 17, para 3.3. No, why I wanted to read 3.2.7, because I was referring to the Madras judgment.
All right, if you want to
It's
read
in that context, para 3.2.7 will have.
All right, please read if you want.
Accordingly, judicial review of an economic policy ought to be restricted to the nexus test wherein the court may only determine if there is a rational nexus with the objects sought to be achieved. That is, to determine the relationship of the means to end. Any other test, including the proportionality test, would impinge on the freedom of the executive and the legislature in enacting and implementing economic policy measures. Going any further would also dilute the well-established and oft-repeated universal position of law that courts should not engage in so-and-so legislation in promotion of economic measures. Now turning over to page 17, para 3.3. The submission that the objectives stated in the impugned notification dated so-and-so are false and illusory objective is a submission calling for examination of the merits of a policy decision. Equally, the test of proportionality is also a test to be applied to the merits of the decision. Submitted having regard to the scope of the jurisdiction in Article 32, read with Article 13 of the Constitution, where Article 13.2 says if a law is repugnant to the extent of violating fundamental rights, to that extent repugnancy, it is void. That will be the criteria which courts will apply under Article 32. Now, read with Article 13, the merits of the legality of a decision, particularly in policy matters, will not be scrutinized. It is wrong to suggest that the three factors, namely terror financing, black money, and fair currency, remain as challenges to the sovereignty of the nation, and its economy should not be addressed at all. It's equally wrong to suggest that because of the very nature of the challenges, chasing them will all be a formidable task and therefore illusory. It is submitted that no state action can be subjected to scrutiny on such propositions. Equally, except on state action being repugnant to fundamental rights, this Honorable Court will not convert itself into the third chamber of Parliament and declare on the political expediency or otherwise of a given measure. The suggestion that courts can scrutinize if false and illusory objects are being pursued is not the legal test which can be applied on any norms or standards, and asking the court to do so will require the court to enter into an area not constitutionally ordained. Executive policies and legislation alike are given effect by the respective branches of government with certain objectives and goals in mind after consideration and deliberation. This may not preclude the possibility that said objectives or goals may not always be achieved to their fullest extent, or there may be something left to be desired in the manner of their implementation. This does not, however, mean that the policy or legislation in question is per se bad or that it deserves to be struck down or rolled back altogether. Well settled that the mere potential for misuse of law or a particular provision of law does not invalidate the law itself. Even a particular law may lend itself to an implementation which is improper, unreasonable, or create discrimination. That alone will not be sufficient to hold the law is invalid on the touchstone of Article 14. In such a case, it is the action under the law rather than the law itself which will be held to be invalid, and there will be no occasion for the court to canalize the manner of exercise, lay down guidelines for implementation thereof. On the contrary, there is presumption that until proven otherwise, the administration of the law is being done in a fair, equitable manner. Particularly in the context of economic decisions, the Honorable Court Arun Kumar Agarwal has held matters relating to economic issues have always been an element of trial and error. So long as the trial and error is bona fide and with best intention, and such decisions cannot be questioned as arbitrary, capricious, or illegal. This court in state of MP was so and so, referring to Frankfurter. We must not forget that in complex economic matters, every decision is necessarily empiric, and it is based on experimentation or what we call a trial and error method, and therefore its validity cannot be tested on any rigid a priori consideration or on a question of aptly any straitjacket. In Metropolis Theatre, I read out that portion today morning. Then paragraph 4, I only
Please proceed.
paragraph, then the next page. So the heading talks about economic legislation not permissible. I only read paragraphs 4.3 and 4.4.
Yes.
The court cannot be called upon to render a decision on the question between inaction or perfection in the sphere of economic policy and legislation. The court shall not render decisions or declarations into moot or academic question, particularly no tangible relief with reference to alleged procedural unreasonableness can be meaningfully granted. Now, one small correction I would like to make in the written note. I think you'll also kindly turn to that page 10. There is a small correction I would like to make. Para 2.4.11. There's a small mistake which has occurred here. In that paragraph about a word more than once in a section, in the fourth line, the first any, but the second uses the word, I think it should read as the word any may be singular or otherwise.
May be
singular or otherwise.
Otherwise it's supposed that also because we are discussing in the morning.
No.
It can't.
Certain way something has come wrongly here.
If the government takes a policy decision to wipe off the entire currency.
Correct. It can be singular, it can be plural, it can be anything.
So we hope that such a situation may never arise. But then
I have done with this note may just
Very comprehensive note, Mr. Attorney.
I'm extremely glad.
All right.
And
Well researched.
obliged. I wanted to just bring to your lordship's notice on the excessive delegation. Had handed over a note. Therefore,
Yes.
please hand, please. Okay. Okay. In the first judgment, which goes back to the year 1944, the third paragraph. As we have said, the Constitution has never been regarded as denying to the Congress the necessary resources of flexibility and practicality to perform its function. And irrelevant, the Congress might itself have prescribed the maximum price or have provided a more rigid standard by which they have to be fixed. For example, that all prices should be frozen at the levels of obtaining during a certain period, a certain date. Congress is not confined to the method of executing its policy, which involves the least possible delegation of discretion to administrative officers. Then the next judgment, the first paragraph, Section 232B of the Trade Expansion Act of 1962, amended by so-and-so, provides that if the Secretary of the Treasury finds that an article is being imported into the United States in such quantities or under such circumstances as to threaten or impair the national security, the President is authorized to take such action and for such time as he deems necessary to adjust the imports of the article and the derivatives so that the imports of the article will not threaten to impair the national security. President Nixon's 1973 program apparently did not fully fulfill the objectives to which it was directed. Accordingly, the Secretary of the Treasury, acting pursuant to so-and-so, initiated an investigation to determine the effects on the national security of imports of petroleum and petroleum products. When the Secretary of the Treasury, Simon to Assistant Secretary, directs the Secretary, if it is appropriate to do so, hold public hearings, otherwise aforesaid interested parties an opportunity to present information and advise as part of such an investigation. And it goes on, the next paragraph. The Secretary submitted a report on the investigation to the President, intimating that the measures then in force under 223B had indeed not solved the problems with the director. Secretary indicated the United States dependence on foreign oil had continued to increase since 1966, and that foreign sources currently account for well over a third of domestic consumption. Secretary concluded crude oil, principal crude oil, derivatives, so on, etc., and related products derived from natural gas and coal are being imported to the United States in such quantities as to threaten to impair the national security, and the foregoing products are being imported to the United States in circumstances as threaten the national so-and-so. Then next para 5.555, the President agreed with the findings of the Secretary's investigation, concluded the necessary and consistent national security so that discourage importation in the United States of petroleum products, and related products. Presidential proclamation invoking 232B issued a proclamation 75 with effective immediately raised the so-called first-tier license fees that imposed in 1973 to the maximum levels previously scheduled to be reached only some months later. Then one paragraph later, in Hampton, so-and-so, United States, this court upheld the constitutionality of a provision empowering the President to increase or decrease import duties in order to equalize the difference between foreign and domestic production costs for similar articles. That the court said, if Congress shall lay down by legislative act an intelligible principle, the President is directed to confirm such legislative action is not a forbidden delegation of legislative power. Then, and fulfills that establishes a clear precondition to presidential action inter alia, finding by the Secretary of the Treasury article being imported in United States in quantities, circumstances that threaten impair national security, Moreover, the leeway that the statute gives the president in deciding what action to take in the event of preconditions are fulfilled is far from unbounded. The president can act only to the extent it is necessary to adjust the imports or so and so. And in the light of these factors, our recognition of necessity fixes a point beyond which it is unreasonable and impracticable to compel Congress to describe detailed rules. So we see no looming problem of improper delegation that should affect the reading of section 232B. Then, let's kindly turn over to the Indian law, serial number 6, Gwalior Rayon. Delegation of lawmaking power has been said as the dynamo of modern government. Delegation by the legislature is necessary in order that the exertion of legislative power does not become a futility. Today, while theory still affirms legislative supremacy, we see power flowing back increasingly to the executive. Departure from the traditional rationalization of the status quo arouses distrust. The legislature comprises a broader cross-section of interests than any one administrative organ. It is less likely to be captured by particular interests. We must not, therefore, lightly say there can be a transfer of legislative power under the guise of delegation, which would tantamount to abdication. At the same time, we must be aware of the practical reality. Thus, Parliament cannot go into details of all legislative matters. The doctrine of abdication expresses a fundamental democratic concept. At the same time, we should not insist that lawmaking as such is the exclusive province of the legislature. The aim of the government is to gain acceptance for objectives demonstrated as desirable and to realize them as fully as possible. The making of law is only a means to achieve a purpose. It is not an end in itself. The end can be attained by the legislature making the law, but many topics, the subjects of legislation are such, they require expertise, technical knowledge, and a degree of adaptability to changing situations which Parliament might not possess. Therefore, this end is better secured by extensive delegation of legislative powers. The legislative process would frequently bog down if a legislature is required to apprise beforehand the myriad situations which it wishes a particular policy to be applied and to formulate specific rules for each situation. And that's as widely stated as necessary, if I put it like that. The presence of Entry 8 clause in many of the statutes is a pointer to the necessity of extensive delegation. The hunt by court for legislative policy or guidance in the crevices of a statute or the nook and cranny of its preamble is not an edifying spectacle. It is not clear what difference does it make in principle by saying that since the delegation is to a representative body, that will be a guarantee delegate will not exercise the power unreasonably. For if ex hypothesis, the legislature must perform the essential legislative function, is certainly no consolation. The body to which the function has been delegated as a representative character. In other words, if no guidance is provided or policy laid on, the fact that the delegate has a representative character could make no difference in principle. Then next, serial number 13. Paragraph 3. They function best when they concern themselves with general principles, broad objectives, and fundamental issues instead of technical and situational intricacies, which are better left to better equipped full-time expert executive bodies and specialist public servants. Parliament and the state legislature have neither the aim nor the expertise to be involved in detail and circumstance. Then nor can Parliament and state legislatures visualize and provide for new, strange, unforeseen, and unpredictable situations arising from the complexity of modern life and the ingenuity of modern man. That's the raison d'etre for delegated legislation. That's what makes delegated legislation inevitable and indispensable. Parliament and the state legislature endowed plenary power to legislate upon any of the subjects entrusted them by the Constitution, subject to the limitations imposed by the Constitution itself. The power to legislate carries with the power to delegate. Excess delegation may amount to abdication. Then, few lines later, legislate it must by laying down policy and principle, and delegate it may to fill in detail and carry out policies. The legislature may guide the delegate by speaking to the express provision empowering delegation or other provisions of the statute, the preamble, the scheme, or even the very subject matter of the statute. That's what I've been trying to tell your lordships. The very subject matter of the statute, the preamble, introduced in 2016, and look at the scheme of the act. So will you say RBI should be denied a certain authority in the monetary policy, currency management, and so on and so forth? So if guidance there is, wherever it may be found, the delegation is valid. A good deal of latitude has been held to be permissible in the case of taxing statutes. Same principle, a generous degree of latitude must be permissible in the case of welfare legislation, particularly those statutes which are designed to further direct the principles of state policy. Give me the. The first page, the Federal Energy Administration versus so-and-so. I read out about the president issuing a proclamation following the Secretary of State's investigation. I would put it like this, if I can paraphrase it. The emphasis of the US case in the case of Federal Energy Administration is that even the words as he deems necessary, the word as he deems necessary was not read to mean there was improper delegation lacking guidance. The interest of national security was itself deemed to be sufficient factors in guidance. It can come back to you. 1978, please hand over to the court. Please. We have both the Rajya Sabha and the Lok Sabha debates. The 3-page one is the Rajya Sabha debate. Kindly turn over to. Just Nagaratna's got it?
Yes.
Sorry.
This is the Lok Sabha.
Yeah. There's a running number there at the top here, 146. I'll be kindly turn over to page 148. That's the next page. And before I read that page, please come to page 154, the minister's statement, page 154. Lords, have you got it? Sri H.M. Patel, sir, I am glad to say that this bill has a limited objective as already stated. I was asked whether the government had any particular motive other than that which is stated. I do not see why there is any need to look for motives other than the objective for which the ordinance was promulgated and the bill is brought before the House. It is because these high denomination notes, that is 500 and 1,000 at the time, were being utilized for financing illegal transactions or for illegal purposes. It is clear that this had a limited objective. The total number of these notes in circulation is worth rupees 145 crores. Just hold on, we are going back there 1978. Therefore, the quantum was certainly less. The total number of notes in circulation in this country today is over rupees 8,000 crores. Therefore, quite obviously, this could not have ever been designed to achieve anything or the nature of trying to attack even the black money problem, etc. It had no such objective. So it had the objective that is mentioned here. To pick up the 46 Act. 46 Act. Then kindly turn over to page 140. What is it? 1946. Here. So the 3-page, 4-page. Just begin.
Circle.
The paragraph. I may also point out in this connection, there's almost a universal demand by experts for the demonetization of 100 rupee notes.
Reading? Where?
Page 140, the second page.
148. Page 148.
148.
The page number is at the top, 140.
Yes.
The second paragraph on the right hand side. I may also point out this connection, almost a universal demand by experts for the demonetization of 100 rupee notes. If any impact were to be made on unearthing the hoarded money, and if inflation were to be arrested, the Finance Minister of Tamil Nadu and Chief Minister of Tamil Nadu were among those who were emphatic about the need for the demonetization of 100 rupee notes. But that has not been done. Demonetization of such notes would have given the shock of their lives to the black money operators. So an opportunity had been lost for putting new life into the economy by checking these evil forces. I admit the administrative complexities would have been tremendous, but the beneficial effects on the economy would have been far more tremendous. It is not beyond the organizing capacity of the central government to have brought in such a measure and implemented it successfully in a thoroughgoing manner. If that was a level of debate in Parliament in 1978, I'm sure the Parliament did not think that the three evils to be addressed were illusory and false. Now turn over to the next Lok Sabha debate. Page 640, 646. The page numbers are available at the top of 646, the second paragraph, and the right hand side again. Lords have got that page? Very good. The ordinance was promulgated on 16 January 1978. We have to see the relevant figures and also as to what was the effect of demonetization in our economy and also the currency circulation. According to the figures that are given by the Honorable Finance Minister, high denomination notes worth about 140 crores were in circulation, 1,000 rupee notes worth about 125 crores. And it will be not more than 0.61%. Therefore, this will not have any great effect on the economy. This House very well knows about the report of the Vanchu Committee, which recommended in 1970 that even the 100 rupee notes should be demonetized to curb black money. But unfortunately, the bold step taken by the Janata government did not include the demonetization of the 100 rupee notes. There are a number of defects, etc. And then the last part of that particular paragraph, I request the Honorable Finance Minister to see that some steps are taken to demonetize the 100 rupee note, because only then we can curb black money, which is running a parallel economy in our country furthermore. And then another member at page 651. In the middle of that page, on the left-hand side, the sentence beginning, "It is a serious matter if this happens." Then the next paragraph. It is said, Lordships have the paragraph. In the left-hand side at page 651.
It is said.
It is said that black money operates through 100 rupee notes.
Yes, bro.
Very clever people have changed their 100 rupee notes into 10 rupee notes. What proposal does the minister have to curb and control black money? In this connection, an isolated suggestion of demonetization of 100 rupee notes will not help. It is only one of the processes. Way back in 1978, at a lesser level of black money operation, this is what the parliamentary debate talks about. So I would appeal to the minister that he should follow the principle of demonetization by curbing the generation and expansion of mismanagement of black money. I hope he'll come forward with concrete measures with purpose. Now we are in the year 2022. 2014, a white paper was placed before the parliament. That white paper is on record. It talks about the need to balance the impact on people, the poor and the underprivileged would suffer hardship where the cash is to be curtailed. At the same time, look at the larger objective. It talks about balancing that. So in 1978, if Parliament was saying you should have demonetized the entire currency, 100 rupees including. So we are talking about 86.4% because it has become pervasive. These two denominations are the major currencies today, denomination. So either somebody will come and say, why 86.4%? Why not 10%, 20%, 30%? So you will have a calibration where the least impact factor should be taken into account and then find out whether the least impact factor would serve the purpose of addressing these evils. Therefore, the question of percentage is hardly the point to be taken into account. The question is if the denominations in question are the denominations to be accounted for, dealt with for the purpose of addressing this evil, the court will definitely leave it to the policy-making authority to calibrate them and then deal with them. As I said, now the impact is seen for about 5-6 years, how it's happening. So therefore, I would appeal to the court before making some final conclusions that don't look at it in isolation. As this parliamentary debate says, it is not only one of the processes. See, one of the processes, like we are looking at a huge mountain, and 26 is like a sledgehammer. And the sledgehammer, you use a mountain to knock out a mountain. Give a little more strength to the sledgehammer, don't weaken it. You may have other occasions where other demonetization, we look at the currency management. So internal monetary stability, state actors floating in fake currency all over our country. So this can't be calibrated at all. You can't have a scanning machine by which today I have 100,000 notes on fake currency, tomorrow I will have more. I mean, where do you have this kind of thing happening? Therefore, we are touching the life nerve or the monetary policy of a country where one important step was thought to be necessary. Of course, as I said, this balancing would have had all kinds of issues. The court would, at the least, address those balancing issues, find out what remedial measures are possible within the framework of the law. So finally, on the question of this cutoff date, we said once you move the cutoff date, then of course, the stability, the integrity, the internal integrity of the whole decision-making process will also be diluted. So that's why we find considerable difficulty in accommodating people who had very genuine grievances. Somebody put 30,000 rupees in his paper book and could not get it. So therefore, the government should formulate a policy where within a period of 1 year, let us say, all possible exchange processes will be completed. And then we would be able to have a watchdog at every bank and outlet where this exchange can take place and see that people do not really get their back money and fake currency exchange. So what is that we are talking about? I just hand over to your lordships a few references to judgments. But I must also address this question as to whether the difference between 4678 and 2017 will have any bearing on the question of judicial scrutiny. If on the one hand it is argued that in 46 and 78, Parliament went into action mode and he did not look at 26, he did not ask RBI to take any steps. And you could have followed the same measure. The two important objectives in 46 and 78 were very different. Today we are in an entirely different globalized economic and other domestic situation. So please don't compare a 46 and 78 with what's happening today in the the economic situation of the country. And those three evils which will continue to, grin at you and say, look here, I'm your challenge. Therefore, to say that never use 26, you should not have used it, go to Parliament. On the one hand, look at what Parliamentary debates in 78 said. You could have used it much more. In 78, Parliament says, why only 500 and 1,000? You could have also demonetized 100. Spread it little wider. If today, without going to an initial parliamentary process, if that wider net is stretched and put into action mode, and later Parliament says, yes, I give my approval to the 26/8/11/2016 notification, then Parliament has effectively come into a deliberation. It has approved it. Therefore, this distinction, I think, would be a distinction that the court will not enter into. And if it all entered, for what purpose? Will the court say you have chosen a wrong mode of action for addressing these three evils? Address it only through Parliament. I'm not sure the court would enter in that kind of suggestion to parliamentary procedures and practices. And the plenary exercise the power by the Parliament. You can copy of this. Academic. Constitutional practice in US Supreme Court. I only picked up 3 judgments for Lordship's notice. And it can happen in a number of circumstances. The last one is that. Kindly turn to page 9 of this note. It's again a very short judgment. At least some paragraphs have been set out here. This action, even though it's called per curiam, this is how the opinion runs. This action was commenced to restrain certain persons from proceeding to incorporate the village of Tarrytown under the General Act of Legislature authorizing the incorporation of villages. The persons made defendants are those who signed the notice required, and the officers of the town would be inspectors of the election. A temporary injunction was obtained, which was resolved, and the election was held, and the majority votes determined in favor of the incorporation. And the proceedings for incorporation have been perfected, village officers chosen, and the corporation is in operation. By a supplemental complaint, these facts are set up, and judgment demanded that all these acts be declared null and void. The grounds of the action are that the statute was not complied with, and the statute itself was unconstitutional. We do not deem it necessary to determine whether the action is maintainable as it originally commenced. As it appeared upon that trial and is presented on an appeal, no effectual judgment can be rendered in it. The act sought to be restrained have been consummated, and from a project to incorporate a village, the village has been incorporated. The defendants are not necessarily a proper party to the action upon so-and-so. The village itself and the trustees are now exercising the franchise or the necessary party to the action, and the injunction restraining the defendant would have no practical effect upon the corporation. We do not deem it proper, therefore, to express an opinion upon the points presented involving the validity of the statute or the regularity of the proceedings under it, for the reason the decision could not be made effectual by a judgment. The general term might perhaps reverse the judgment and directed the proper parties to be brought in, but it is not the province of the court to do so. Besides, so-and-so, a real act nature of quorum to an appropriate, if not the only remedy. The one broad principle, as I said, the US courts have always been following, and I think this principle is worthy of acceptance in this matter. What else do you want to say? That Mhm. Analysis of the doctrine of proportionality. Sometimes it becomes useful to just look at it. I don't want to engage your lordships. It only says sometimes there is, as I said in the morning, unconstrained moral reasoning will always something which come in the minds of the court in dealing with certain set of matters. And then they are not wholly out of point. But when an unconstrained moral reasoning in certain areas comes into focus and it permeates the decision-making process, that could be some kind of issues. So this small critique only looks at is what is how various thinkers look at it and how there can be a problem in comparing incomparables. So very often proportionality enters into comparing comparables. Then we enter into comparing incomparable, that could be a problem. So the case on hand is this, where the larger public interest is moving towards a wide range of economic and policy transformations on the one hand. Can you compare it with, certainly, nobody says the hardships are to be belittled. But if you can compare it to the hardships, if the hardships are the only factor to be addressed, the only relevant factor to be addressed, then one wonders, how would you design this whole policy perspective? That is where the proposed test will not be applied. The court then being asked to enter into a designing of a policy perspective, either to address these evils or not to address them at all. I'm not very clear. Again, to come back to only Article 13, it says laws which are inconsistent with fundamental rights to the extent of inconsistency can be declared to be void. That's why part 3 occupies an important field in our adjudicatory process. But minus stands part 3 issues, or under a very attractive propositions of 14, 19, and 21. The court is being called upon, as I say, to design a policy framework which will be flawless, which will be completely out of any blame, things like that, and so on and so forth. I submit with great respect, the court will not get that into that. And my learned friend will address on the question of RBI and its role in certain respect. And I'm extremely thankful for lots of kind question. And I must read para 195 as Valentin wanted me to read and give my comment on that and the cryptocurrency judgment. Para 195 at page 377. Let me read it. I wanted to read it after I thought I would have made all these submissions and come back to para 195. Yes. 37. There can also be, at page 377, there can also be no quarrel with the proposition that banking channels provide the lifeline of any business, trade, or profession. It is especially so in the light of the restrictions on transactions contained in section so and so. And currency itself has undergone a metamorphosis over the century, from stone to metal to paper to paperless, and we also assured the digital age, cashless transactions require banking channels. Therefore, the moment the person deprived of the facility of operating a bank account, the lifeline of his trade or business is severed, resulting in the trade or business getting automatically shut down. Hence, the word now showing that larger public interest warranted such a serious restriction bordering on prohibition is heavily on RBI. Certainly, yes. I suppose I carried your lordship through my submission, and the facts based before lordships, this has been discharged. And this, give a copy to the board. Again, this is only a list of judgments that courts will not. You give it to you. We give it to the court. You can copy. question posed was, did RBI have knowledge about information about the value and volume of notes in circulation 2015 or 16? They have it almost on an everyday basis. They publish it. There are annual reports published. And this is as regards the 2015, 16. So 15, 16. Of the Central Board of Directors and the working of so and so for the year ended June 30, 2016. And in the next page, we have the trends in currency, where at the top, bank notes in circulation at the heading, and the table gives a complete figure of the total bank notes in circulation or various denominations.
So Venkataraman, they are the ones who issue notes.
That's right. To say that they have no information, and what kind of information, I'm not very clear.
No, I didn't say RBI did not have information. I said that the information placed before the RBI board when it met.
We will address this.
It's still not produced any of the documents for them.
Milord, this last bit, Milord, which my learned friend is doubting whether the RBI was aware of this, is a published data, annual reports of RBI. To say that is a with a small bit of housekeeping arising out of what happened in the morning. Milord, the 9 matters relating to district central cooperative banks, which are not referred to the Constitution bench. That list, Milord, we have prepared. Now, Mr. Seshadri Naidu, Milord, had sought the withdrawal of one case relating to district central banks. Milord, it was effectively objected to by Ms. Manjula Gupta on the ground that there is an issue in the present matter, question 9, which deals with it to some extent. Now, Milord, we have found that there are other matters also before your lordship, which are district central cooperative banks. But, Milord, that point has not been argued by any petitioner before your lordship. Milord, it is a separate issue. It has its own facts. So, Milord, if your lordship wishes to hear arguments on it, Milord, petitioners must at some stage address. Or we are, Milord, there is no difficulty if this entire question of DCCBs is kept out of the Constitution bench.
We are also proposing, Mr. Gupta.
That's all right.
We are also proposing, we will, at the end, we will say all other questions shall be addressed before the, this is what we are proposing to do,
yes,
actually.
In which case, Milord, I should, yes.
Please continue.
Yes, ma'am.
What is the context in which that question has arisen in order to detag those cases?
My lord, I'll tell your lordship the entire background in a minute. My lord, there are these district central cooperative banks, which, my lord, are below, my lord, the state cooperative. Now, my lord, they are actually cooperative societies. They are not banks in the true sense of the word within the meaning of banking company. So, my lord, there was a question as to whether they must function as a bank does in receiving deposits from their constituents and handing it over to the Reserve Bank, as all banks were required to do. My lord, there was some confusion on the 8th. This confusion was resolved on the 9th by saying that though you are strictly speaking not banking companies, but you are now told that you must do what the other banks are supposed to do. My lord, what banks were told to do was they had to reconcile their accounts on the 9th. My lord, the 8th was the notification. On the 9th, my lord, it was a bank holiday declared specifically for the purpose of banks reconciling their books and coming to a conclusion as to the amount of cash that they were holding on that date. Then, my lord, on 10th, they were supposed to give a declaration of the amount that they were holding and also, my lord, to deposit the amount. Now, this was to fix the opening balance, because if that opening balance was not fixed, any amount of cash could have been accounted for as opening balance by saying that, oh, we already had this in our hands on the 8th. My lord, DCCBs, my lord, are unfortunately not fully regulated. They are not under Reserve Bank regulation. There is some supervision of, my lord, NABARD, which is a subsidiary, my lord, agricultural bank, my lord. It's a subsidiary of Reserve Bank of India. Some supervision is there, but not to the extent at all that other banks are. So, my lord, it became a rather, my lord, it became something of a problem, my lord, in this process.
Cooperation is a state subject.
My lord, cooperatives is a state subject. Then, my lord, so what happened then was that some of them, my lord, did not disclose that. They are before this court saying that we should not be asked to disclose. Secondly, my lord, on 10th to 14th.
No, actually, what has happened is
Yes.
we have a tabulation of the prayers made
Yes.
in all the writ petitions.
Yes,
We'll tell you the statistics.
lordship.
There are 40 writ petitions.
Yes, my lord.
There are 12 transfer petitions.
Yes, my lord.
6 special leave petitions.
Yes,
And 1 transferred case.
lordship.
Out of them, what was listed originally at the instance of the district cooperative banks
Yeah.
were about 6 writ petitions. Some of those writ petitions, only 1 or 2 of them challenged the virus of 8/11/2016 notification.
Correct,
Therefore, they form part of the batch, though the petitioners are district cooperative banks.
lordship.
Other district cooperative banks, the prayer was only to the limited extent that we should also be given the transaction right to receive the specified bank notes and return them.
Yes,
So that question, whether that question survives at all now, because the question of now receiving the specified bank notes, the only prayer, some of the district cooperative banks, the only prayer was, we must be allowed to transactional rights. That transactional rights cannot now be granted to them
my lord, may I just
on the specified bank notes, on the
Correct.
specified bank notes.
Quite right, my lord. My lord, may I just add one thing to that? They were, my lord, there was a situation whereby they did transact between 10th to 14th of November.
That's right.
Now, when that happened, they were asked to stay their hands. They would be given instructions later on. Those were the instructions which were given, my lord. A window of opportunity was opened to collect that money and give it to the RBI in June and July of 2017. No, yes, you're right. Not to collect, quite right. Not to collect. Whatever has been collected between 10th and 14th can be deposited with RBI in June and July. So, though whatever was done by June and July. Now, if somebody has not taken the advantage of that window of opportunity, there can be no question. And, my lord, there is no, they did not have, my lord, the power to receive cash after the 14th. So if they have done that, they have done that illegally. So therefore, my lord, there's nothing to be done about that either.
My lords, may I just clarify?
And only one more thing before my learned friend starts. My lord, in my record, my lord, at page 33 of one of our affidavits, which is in the compilation, we have noted, and your lordship, my lord, has the statistics, my lord, that there were 2 writ petitions or more, my lord, as your lordship has said, but there was also, my lord, 3 SLPs. The SLPs came from the state of Rajasthan, where, my lord, this similar prayers had been made. So, my lord, this is not even, my lord, what Mr. Diwan's clients, my lord, is facing, because that is the question of an individual or an entity or a constituent of a bank going to the bank with their currency and that being accepted. That's a different thing. Now, the DCCB is the bank surrendering the currency to the Reserve Bank of India. Now, therefore, my lord, there are some which are in this list. There are some which is outside. My lord, your lordship have framed one question, but my lord, if your lordship wishes to keep the whole lot out, all I will do is, my lord, collect the particulars of the ones which are before your lordship today and hand it over to your lordship's officers, so that if your lordships wish to keep that apart, then the whole lot should go out along with the question number 9. So the DCCB issue will therefore not be, my lord, before the Constitution bench at this point.
May I just clarify, my lords, it's not the DCCB only, but it's the primary. Manjula ji was making submission on primary agricultural credit societies, my lords, at the primary level. What happened with them was that on the 8th, whatever cash they had with them on the 8th was not taken either by the DCCB or and they could not open their bank accounts in any other nationalized banks. So the cash that was left on 8th is the only one. That is what is an issue before in those cases, my lords.
No.
The cash left on 8th, because DCCB had instructions to accept only from the individuals and not from the institutions. So these were institutions, they did not accept the cash which was left with them because of sale of fertilizers or some deposits that were made by the individuals in the society. Some societies have 6 lakhs cash, some have 8, 11, something 16, something like that, not more than that. It is only about the cash left on 8th evening, not of 9th, 10th, or because 10th and 14th and others were taken care of by it's only with regards to the 8th that the issue.
We will deal.
Just one line, my lords. The issue that would be before my lords would be whether it is reasonable not to allow us that the cash that we are left with on the 8th. Being DCCB not allowed to accept from institutions, we had only our accounts were only with the DCCB. We could have deposited only there. And since nobody was there to accept it, those cash is still left with us. And therefore we are before your lordship.
All right.
That is
My lord, the short answer, my lord, if your lordships are interested at this stage, everybody was allowed to deposit. They were not allowed to deposit in DCCBs. They could have gone anywhere else and deposited.
That is exactly the case, my lords. We did not have accounts in any other nationalized banks. No nationalized banks at that point of time was opening fresh accounts, my lords.
I think we don't propose to go into all these factual aspects in this case.
No, it's only the reasonable, my lords.
Please listen to us. It is not that you are remediless. We will leave it to the division bench, 2-judge bench, to decide all these factual aspects and including the whatever you are suggesting. And I really don't know whether the Supreme Court is a proper place for you to decide these factual aspects. Let us not lose focus on the important constitutional questions. Let us concentrate on that. Let us not deviate from that. Let us not deviate from it.
I just wanted to bring it that.
All right. Anyhow, we are not proposing to answer all these questions. These are all more on facts. Let us focus on the constitutional points raised here. We will answer that.
Why I'm saying it is important, my lords, is the RBI or the other institutions are trying to brush us aside.
That's all right. You can argue. You can argue all those things. After before the 2-judge bench, you can argue all those questions.
What I just want to place before my lord's consideration is that, my lords, all these submissions that we have got sufficient opportunity is not right, in the sense that we all are left with the cash on 8th evening. That opportunity was never granted and we could not have done which I.
All right, we have understood. Yes, Mr. Gupta.
Now, my lord, coming back to the main issue, what I have done is, my lord, I have written down all the propositions which, according to me, my lord, are relevant. Now, many of these have already got addressed by the Attorney General, my lord. So, therefore, I will not be troubling your lordships with them. In some, my lord, I will supplement a little bit. But first of all, my lord, if your lordship permits, my lord, me to place this 2-page only, these are propositions which, my lord, to my mind, my lord, covers the issues which have been raised by the petitioner. First one is the withdrawal of all series of 2 denominations, that is 500 and 1000, is well within the jurisdiction and powers conferred upon Reserve Bank of India by section 26(2) of the RBI Act. Our propositions. Millard, I haven't put it as a question. I'm putting it as an answer. So, Millard, the first question is whether 26(2) covers what has been done in this case. That's number one. Number two, the submission that unless phrase any in section 26(2) is read as some, then the power conferred by the said section becomes unguided, uncanalized and arbitrary, and that is without basis. That proposition is without basis. Then C, it is not correct to say that the process under 26(2) has not been followed in the present case. The procedure laid down has been followed and the process cannot be criticized on the ground of any procedural lapse on the part of RBI or the central government. So therefore, my lord, the first two deal with the interpretation and constitutionality of section 26(2). The next one is, my lord, whether there is any procedural impropriety, which is well within, my lord, judicial review powers. Then comes, my lord, the arguments which relate to, my lord, actual judicial review of the decision. D, the decision to recommend and the decision of the cabinet to accept such recommendation is not subject to judicial review. That's our, my lord, contention. Then, my lord, in the sphere of economic policy making, the Wednesbury principles are of no or little use. The proportionality principle also cannot be applied to the judicial review of economic policy. My lord, I will, my lord, deal with, my lord, the internet judgments in this context. Then, my lord, without prejudice to the aforesaid, the petitioners have failed to establish that relevant factors have not been considered or that irrelevant factors have been taken into consideration. This is on the merits of it. Then it is extremely important. I have kept it separate because this was a suggestion from the other side. It is extremely important that no restrictions are placed on economic policy making by RBI or the government of India by laying down guidelines, my lord, in a court. Because, my lord, that in the judgments, your lordships have noted that it is impossible even for the legislature or for, my lord, the government or RBI to envisage everything which may happen. So, my lord, when that is so, to lay down, my lord, judicial guidelines, my lord, would be extremely, my lord, dangerous in our respectful submission. Then, my lord, H. This now deals with, my lord, the SBN Act. I'll call it, my lord, the SBN Act because that's the act which came in 2017. The SBN Act has given relief to certain categories of persons subject to verification by RBI. Individual cases of hardships that have not been provided for in the Act cannot be gone into. RBI cannot, my lord, go beyond the Act also. My lord, I'll try to satisfy your lordship. Then the submission that section 4 of my lord, Act, it's Act, my lord, not article, I'm sorry, Act 2 of 2017 is unconstitutional, is without any basis. And finally, my lord, it is well settled that the courts cannot issue futile or academic writs. It is also well settled that it does not issue a writ if it has become infructuous, and declaratory relief in such cases will not be given if it involves factual adjudication. Now, my lord, declaring a law to be unconstitutional is a declaratory relief which can be given at any time. But, my lord, to say that look into the facts of the case, judicially review based on the facts, and hold that that particular decision was arbitrary or whatever, that is an adjudication on facts. Once, my lord, that decision is not to be reopened, after that, my lord, it should not be adjudicated at this stage, my lord, is what I will try to show. Now, my lord, I'll go pretty fast, my lord, because if I come back to A, my learned friend, my lord, has already taken your lordship or given your lordship, my lord, a list of the cases my lord, we'll also file a written note on all this, my lord, by tomorrow or day after, my lord. Your lordship has been shown that there are judgments of this honorable court which says that any usually means in common parlance any or all. Now, I just want to add two aspects, my lord, to the argument. The judgments are there, my lord, the same judgments which and in fact, my lord, three of them, my lord, we have put in a compilation which we have made, which we are handing up to your lordships in any event. The first three, my lord, are on that issue. Now, I want to add only two things here, my lord. The first is that my learned friend's contention is that it should be read as some specified series or some specified denomination. Now, what is that sum? Is it 1, 2, 3, all minus 1? Suppose all is 20, then 1, 2, 3, 4, 5, 6 up to 19 satisfies the definition according to my learned friend. It is only if it becomes 20 that it does not satisfy the section. So, my lord, to say that any means sum is, my lord, actually creating confusion in that section. The next question will be, what does sum mean? How many? Can I demonetize half the money? Can I demonetize 25% of the series? Can I demonetize 75% of the series? My lord, it just can't be. So, my lord, that's why any means any and all of that. In fact, my lord, my lord mentioned this. There might be situations where all the money has to be demonetized. My learned friend, Mr. Chidambaram, has actually given what, according to him, are the two legitimate, my lord, instances where demonetization will take place. And one of the two examples that he has given is when the currency of the nation has lost all its value. When that happens, you will demonetize the whole currency. You won't leave a little bit of currency there. So, my lord, there your lordships are being invited to take away that power which permits the central government on a recommendation of RBI to advise that the entire currency has to be withdrawn. So, my lord, this is one aspect, my lord, which I wanted to point out. The second aspect which I want to point out is, my lord, your lordships have taken a decision in many judgments as to the role that RBI plays specifically. And even in the internet judgment, my lord, your lordship has dealt with it in great detail. And one of the aspects of the way your lordship has looked at RBI's powers is that because it is dealing with monetary policy making, therefore it should be, all its provisions should be given wide amplitude. And, my lord, for this purpose, my lord, if your lordship will only permit me to place this, the source case, there is the first time that this honorable court, my lord, dealt with the Reserve Bank of India's powers is, my lord, Joseph Kuruvilla. And, my lord, in my compilation, my lord, I put it at item 5. And if your lordship permits, my lord, I'll just take your lordship through one or two passages in that judgment. In the compilation, it is at page 162. My lord, the citation that I have given is, my lord, from a online web edition, my lord, which I hate, my lord, handing up to the court, my lord, but my lord, all our juniors prefer it because it's the easiest one to access. My lord, in any judgment, the easiest copy to lay your hands on is the SCC online web edition. That does not have a head note. And that, of course, refers to the other paragraphs don't match. We are not even sure that everything that is written there is correct. But, my lord, this is the easiest one to get hold of. Therefore, my lord, when I say we want to place this judgment, they have all given your lordship, my lord, the SCC online web edition.
Actually, SCC paragraph don't tally with the SCR or our AIR.
Yes, my lord, and SCR doesn't even have a paragraph. We have to go by placetum there.
But there is a judgment of this court which has appreciated, you know. There is a judgment of this very question came up before this court.
Yes, yes.
Of SCC only.
My lord, your lordship knows that at one stage, the Supreme Court never accepted any citation other than SCR. But then, my lord, SCR fell behind the times. Then there was no option.
No, see,
for instance, people like us, we put paragraph numbers properly.
Yeah.
SEC, in order to claim copyright,
Oh.
they alter the paragraph numbers.
Oh my God.
And the head noting is an incentive for people to read.
Yes.
Otherwise, 200 pages.
But now, I'm sorry to be wasting time, Milord, but
A copyright case in the High Court.
Yes.
And in order to get over that judgment, they started introducing head notes and then prefatory notes.
Correct.
And all kinds of footnotes also.
No, one
So to say-
paragraph is split into 4 paragraphs.
Therefore, the paragraph, your lordships are right. Your lordships appreciated SCC, not SCC online.
Okay.
in fact, now, Milord, we are finding that SCC head notes are often, Milord, covering most of the judgment. The head notes are no longer, Milord, as pithy as they used to. Also to get over copy.
No, in one of the cases, the head notes ran to 183 pages.
That's correct, Milord. They were just extracts of large parts of the judgment. Good evening. It's at page 162, item number 5. To be absolutely, my lord, proper, the citation that I should give your lordship is 1962 supplementary volume.
Jaideep Gupta, before
Yes.
that,
Yes.
I just want to put it, let us be focused on the argument of the other side.
Yes.
See, their prime, see, they have no problem of your, functioning and all. There is no problem. The focused question is, central government, Union of India and RBI have not followed 26(2).
Yes. So
That is the question.
that's the third proposition,
Let us
my lord,
be
which I'm dealing
focused
with.
on the question.
But, my lord, my learned friend, my lord, has also, my lord, sought to argue both the first two questions, that you should give a limited construction to 26(2), and if you don't give a limited construction,
True.
then it becomes.
That also emanates from 26(2) only.
That's right. It's emanates from 26(2).
Yes.
Now, please see, my lord, para
And
14.
you have not followed the procedure prescribed in 26(2). That is the other question they have.
That's the third question.
Recommendation is.
That's the third question. Yes,
Recommendation part.
I'll come
Let us focus on the questions,
Yes, my lord. That's why, my lord. That's why, my lord, I have given your lordship all the questions that I intend to address your lordship on.
All right.
And, my lord, some which I do not wish to address because the learned attorney has already said.
Yes.
Now, the Reserve Bank's powers came for consideration for the first time of the Supreme Court, my lord, in this judgment. And kindly come to paragraph 14 of this report, my lord, at page 167. And here I'm only showing this to your lordship because here also it was argued that it was uncontrolled and despotic and uncanalized powers were being given to the Reserve Bank.
Yes.
Now, kindly come to 16. Before we consider the arguments of two sides in detail, we wish to say a few words about the position of Reserve Bank of India in the financial affairs of India and also about its place in the scheme of the law. Well, I am relying upon these passages to my lord, argue that the widest amplitude should be given to section 26(2) and that there is nothing unguided about it. These are the two propositions, my lord. The Reserve Bank of India was established in such and such, my lord. Then the history of it is set out. Then para 17. The functions of the Reserve Bank are generally indicated in the preamble as the regulation of the issue of the banknotes and keeping the reserves with a view to securing monetary stability in India and generally to operate the currency and credit system to its advantage. But to enable RBI to function in this manner, it had to be given other powers so that it may function effectively as a central bank. To this end, the Reserve Bank was given the right to hold cash balances, a right to transact government business, which was also its obligation, and to enter into agreements, etc., etc. And then, my lord, they could control the banks. Then 19 on the next page. The above analysis of some of the provisions of the RBI Act shows that the RBI has been created as a central bank with powers of supervision, advice, inspection over banks, particularly those desiring to be included in the second schedule, etc., etc. Then just see, my lord, the last 5-6 lines. No doubt, No doubt the members of the board are subject to removal, but neither integrity nor efficiency is secured only by such guarantee, and we have no reason to think that the Reserve Bank acted in this case or acts in other cases under pressure or from oblique motives, as was pointed out in another tribunal, etc. Please see this language of that extract, All India Bank employees. If it was not the Reserve Bank of India, the only other authority that could be entrusted with the function would be the Finance Ministry of the Government of India. And that department would necessarily be guided by the Reserve Bank, having regard to the intimate knowledge which RBI has on the banking structure of the country as a whole and of the affairs of each bank in particular. The position of RBI being such, as we have stated from the Reserve Bank of India, the next thing is to inquire as to its powers under the Banking Companies Act, etc. And my lord, if your lordship comes to page 171, para 25, last two sentences, 171, para 25, last two sentences, there is hardly any provision where the Reserve Bank's judgment is not made final vis-a-vis a banking company, except rarely where an appeal to the central government can lie. No useful purpose will be served in referring. Then, my lord, your lordships may, my lord, look at para 27, etc. I am not troubling your lordship with anything else here. Para 46 at page 179, and I'm only taking your lordship through all this because this is the source case. In the present case, para 46 at page 179, in the present case, in view of the history of the establishment of Reserve Bank as the Central Bank of India, its position as a banker's bank, its control over banking company and banking in India, its position as the issuing bank, its powers to license banking companies and cancel, it is unanswerable that between the court and the Reserve Bank, the momentous decision to wind up a tottering or unsafe banking company in the interest of depositors may reasonably be left to the Reserve Bank. No doubt the court has also, given the time, performs this task, but the decision has to be taken without delay, and the Reserve Bank already knows intimately the affairs of banking companies and have access to their books. If the court were called upon to take immediate action, it would almost always be guided by the opinion of the RBI. It would be impossible for the court to reach a conclusion unguided by the Reserve Bank if immediate action was demanded. But the law which gives the same position to the opinion of Reserve Bank is challenged as unreasonable. In our opinion, such a challenge has no force, etc. So therefore, your lordship sees, my lord, the position that your lordships have, my lord, acknowledged as far as the Reserve Bank is concerned. So if this is the position, my lord, and the second judgment, my lord, which I won't go into just now, is item 4, Peerless General Finance versus Reserve Bank of India, which your lordships have referred to in the internet case. We'll show, my lord, that when you construe a section which confers powers on the Reserve Bank of India, your lordships do it to give a wide power to the Reserve Bank of India, because these are matters which the Reserve Bank is best suited.
On the contrary, Mr. Gupta,
Yes.
their argument is otherwise.
Yes.
According to Mr. Chidambaram, everything to do with currency
Yes.
has to be with RBI. RBI has the supreme role in that.
Yes.
And therefore, this decision for demonetization
Yes.
should have emanated from RBI.
Correct.
But it has now come in a reverse direction. He has argued on the decision-making process
That's
that within 24 hours, the government writes a letter to the RBI, the RBI
Correct.
convenes a meeting of the board,
Well, that,
takes a decision within 1 hour, the
Yes.
Prime Minister announces it. That's
that's, my lord, if
therefore, the basic condition is that the procedure is not in accordance with 26.
is not in accordance to it. So therefore, my lord, that is for him, my lord, it is an argument in the alternative, because in the first instance, he says that you don't have that power at all. In the second,
The government doesn't have that power. he says.
Government, not RBI.
no, RBI does not have the power to recommend, and the government does not.
On the contrary, he says that it is the RBI who has the power to recommend. And the recommendation ought to have come from the RBI, not the other way around. That is what
No,
he
my lord, I'm only subject to my correction from my learned friend. Any, according to him, is only some. So therefore,
There are three.
That is one of the arguments.
yes, of course, one of the arguments,
First argument is that read any in a limited manner.
limited manner, yes.
If you can't read it any in a limited manner.
Then it will become unconstitutional.
26(2) is vulnerable to vice of excessive delegation.
Yes, correct.
And the third one
Yes,
is that the procedure as prescribed under
has not been followed.
has not been followed.
Yes,
And therefore, though he also agrees that we cannot sit in an appeal over the decision,
yes,
but since the decision making process is flawed,
yes. Therefore, there is a procedural
it
impropriety.
is liable to be
Quite right.
interfered with.
I have no difficulty, my lord, your lordship.
I think these are the three
Yes, correct.
positions.
Correct, my lord. So therefore, I now move on to the unguided and uncanalized power aspect, my lord. And I just want to say one thing about it, my lord. No, before that.
Central government by a notification.
Yes,
It is possible for the parliament also to take the legislative route,
yes.
but that is not the only route.
My lord, that is,
I think that would.
my lord, that is precisely my
That
argument.
argument must be understood, I think. It is not that parliamentary legislation is a mandatory way of doing demonetization.
Your lordship is right. What I said was, there are two ways in which demonetization can be done. One is the 1946 and 78 example by legislation, where the RBI doesn't come into the picture at all. Parliament does it, and I can challenge it on the violation of 1419. That route was taken in 46 and 78. The other route, as my lady said, go through 26. But 26, I said, the process must start from the RBI. So there are two routes. I'm not questioning the two powers, two sources of power. One is Parliament by plenary legislation. One is under 26. And 26, my Lord Justice, if I summarize my arguments 1, 2, 3, the first argument and the second argument. But the most important was a decision-making process in accordance with 26(2).
Now, my lord, in the affidavit which my learned friend placed, it was stated that
Whose affidavit?
my lord, this is, my lord, filed by Miss Kamini Jaiswal, which my learned friend placed in some detail, my lord.
No, that was not argued in all this. You please focus on whatever his arguments, If something is not argued, we will not go into all that.
I'm not
Please focus on these three
I'm
questions.
not asking your lordship.
Actually, frankly, there were no, what is that argument against RBI here? It was virtually against the Union of India, actually. There was nothing against you. I think you can straight away, you can accept.
On the contrary, he is pleading supremacy of the RBI in all these matters.
Actually, the argument, as my brother said,
Yes.
was supporting you. You are belittled, you are not taken into confidence, etc., etc.
Well, I'll just read one passage from this affidavit which my learned friend placed. It is submitted that Parliament has the same power in 1946 as in 1978 as in 2016. Nevertheless, Parliament concluded that the demonetization that was intended could not be done under 26(2) of the RBI Act and required separate legislation. In 1946 and 78, Parliament intended to declare all series of a specific denomination. Since that power was found to be not available in section 26(2), Parliament passed a separate law on each of these two occasions. My learned friend's argument was, if I recollect, he said that why else? Why else would I legislate? If I had the power under 26, why else? Why would I go to legislature? Milord, there is a very simple answer to that. And that answer, Milord, is now being borne out by the records which he has himself submitted. You go to legislation when the governor, you do not want to have the governor central board's opinion, when you want to bypass RBI. And Milord, in both those two cases, your lordship has seen.
Governors were against demonetization.
Your lordship has seen that. In both those two cases, Milord, the Reserve Bank did not appear to be in favor of demonetization. Therefore, Milord, legislation. That's the reason. Not that they had intent, they knew that they didn't have the power under 26. So, Milord, I close this point, Milord, here and move on.
And also the legislation was in respect of all series of two particular.
Two particular denomination, exactly like ours.
That is why notwithstanding.
Notwithstanding, quite right, my lord. Notwithstanding 26, etc. And my lord, there are small arguments here, my lord, that if you go by way of legislation, then there is a debate. There is no debate because in every situation, you go by way of ordinance. You have to go by way of
I want
ordinance.
to only answer one question perhaps.
Yes, yes.
Whether you are taken it into confidence or not, that's all by the government. Before demonetization.
Oh, that is fairly simple.
That is the only, that is their argument.
Right. So then, my lord, I'll move on to the third question.
Or as you read one judgment, you had some intimate knowledge.
Yes.
So there you read some judgment.
Yes, yes.
Intimate knowledge.
Lordship.
So you had intimate knowledge without.
So, my lord. Now, my lord,
You read one of the judgments.
therefore, yes, I have only placed one judgment. That is that Kuruvilla judgment.
Judgment.
Intimate knowledge, because my lord, that's what the Reserve Bank is required to do. This is their job. My lord, monetary policy, my lord, is the express mandate of this act, and monetary policy, my lord, includes currency management. So therefore, my lord, this power is given to RBI. RBI is the expert, which I'll show.
No, what I meant is intimate knowledge of demonetization, not intimate knowledge of your currency.
My lord, currency management includes demonetization. My lord, I think, my lord, the one argument which has not been made, and rightly so, is that demonetization, these three objectives have no nexus with demonetization. That argument has not been made. Because, my lord, demonetization is certainly one way in which these problems can be tackled. Whether it can be tackled well or it cannot be tackled well is a different issue. But it is definitely having nexus. So, now, my lord, as far as C is concerned, that it is my submission, my lord, that it is not correct to say that the process under 26(2) has not been followed. My lord, your lordship knows what has happened, my lord. The attorney has also indicated.
Yes, yes.
Discussion started, my lord, earlier. Discussion started earlier, but my lord, demonetization is such a decision that this discussion will always be fragmented. You will not one day open a note sheet saying that whether to demonetize. Because if you open that note sheet, then immediately, my lord, this will become public knowledge. So therefore, my lord, you will collect information from here and there. And then, my lord, somebody will put it together at some senior level, my lord. That's the only way this thing can go ahead. So therefore, my lord, the discussions, my lord, appear to have started in February. But, my lord, now we come to, my lord, what is the requirement of the section? The requirement of the section is that the last two steps in this process is that there must be a recommendation from RBI and there must be a decision by the central government. These are the last two steps. Their affidavit says that the first step is RBI, because they say that if you read section 26, it has to be initiated by RBI. But that's where, my lord, the fallacy lies in my respectful submission. My lord, that was paragraph, my lord. We'll come to that. Where is that affidavit gone? We've taken it away. My lord, in the affidavit, my lord, the way that this argument came in was by saying that it has to be initiated. That is at page 8. I'm just reading.
He has argued that.
Yes, your lordship remembers. So, my lord, my respectful submission is if you look at 26(2), it does not talk about the process of initiation. It only says that it will not end without these two. There has to be the penultimate step is a recommendation. The final step is a decision by the central government. Now, my lord, a situation like this can be initiated in many ways. It can happen, my lord, it can happen suo motu in the RBI. It can happen because of some discussion or something has taken place on an international level. It can happen at the instance of a state government. Certainly, my lord, it can be initiated by the central government. Because what is happening is the central government has a problem. Black money is a problem. It's a problem, my lord, which can be sorted out through the offices of RBI. But, my lord, it is a problem which affects the nation. Then, my lord, comes terrorism. Now, RBI is not, my lord, having intimate knowledge of terrorism. Facts have to come from somewhere. So, my lord, it is perfectly normal for the central government to raise the question. What do you think we should do? And then comes a recommendation. Recommendation can go either way. Your Lordship is right. We could have said no. We don't think it is right. That is what happened in the last two demonetizations. Or we could have said, and in this case, we did say that very well, it might be appropriate to do it that way. And that, my lord, goes back to the central government, and the central government then says yes. Now, there also, my lord, the central government has a discretion. If I say go ahead with the demonetization, the central government may still decide that no, we won't, for some reason, because the language is may. Now, this is the process in the, under the law, under the section.
Even if you don't recommend,
Yes.
still the central government may decide to go ahead.
May decide, but it seems, my lord, that in that event, it might have to bypass RBI and might choose the legislative process. My lord,
If you read section 26(2).
yes. On recommendation of the central board, the central government may by notification declare. Now, it doesn't say, of course, what kind of recommendation, a positive or a negative recommendation. What will happen if there is a negative recommendation by the central board? The central government may do it still. That's why, my lord, the Attorney General said that because we are not faced with that fact, we are not required to finally take a position on that. That's all.
On the basis of hypothesis.
That's right. It's a hypothesis, so therefore we don't have to go that far. Anyway, my lord. Now, my lord, momentous decisions are taken in this court in a matter of minutes. Similarly, my lord, when the central board of the Reserve Bank sits, my lord, they are not going to start by taking a pen and paper and start writing down from scratch. They are, my lord, people drawn in from various, my lord, walks of life, and also, my lord, experienced members of the who have gone through the Reserve Bank of India. So, my lord, they have a certain amount of information readily available. Minutes are given to them, they take a decision. So, my lord, the recommendation is the decision-making process of the RBI. That can take place.
Compare this court, you know, for with the RBI. Here we hear the lawyers in the open court and argue. And
Yes. Of course, your lordship hears us, but my lord, that doesn't mean. No, my lord, I'm not, my lord, drawing your lordships into this controversy. What I'm saying is,
Gupta, for a miscellaneous day, we read how many days, you know, to get ready for the examination on that day.
Very well, my lord, I won't go ahead with this analogy at all. All I'm saying is, my lord, that the time or the speed, my lord, does not itself mean that there's something wrong with the decision making. This process of demonetization, two aspects. One is, my lord, confidentiality has to be there, and speed has to be there. Without it, my lord, demonetization cannot possibly succeed. It's stillborn from the beginning itself. So therefore, my lord, the speed at which this decision was taken ought not to be.
What you're saying, you were consulted.
My lord, we gave the recommendation. There is a letter of the 7th in which, my lord, they have raised the question. My lord, these are in affidavit, my lord. We are not, my lord, going anywhere beyond the record. 7th, they raised the question, and then, my lord, there was a central board met, and when the central board met, they decided to recommend. And when that recommendation went to the central government decided to act. So the process was followed. Process is followed. You cannot say that the process is not followed. In fact, my lord, there is one other canard here, that there was no quorum, or that rather we do not know whether there was quorum or not. My lord, there was quorum, we have stated on affidavit. The quorum is decided by the regulations, that quorum was met. There's no difficulty with that. My learned friend also says that there were some vacancies in one category of, my lord, members.
Quorum is, I think, 4.
Quorum is 4.
And out of that 4, one has to be among that.
From one has to be from that
C category.
C category, 81C.
81C, and there were only, according to him, there were 7 vacancies.
Yes.
And only 3 were filled in.
So therefore, my lord, one of them was there in the quorum. Now the vacancy in the other 7, if it does not affect the quorum requirement, then, my lord, the vacancy aspect cannot be an independent ground because section 8.5 says that no decision will be called into question on the ground that there were vacancies in the board. So therefore, that's also, my lord.
If the quorum was there,
Yes,
have you stated on affidavit there?
I have stated on affidavit that the quorum was there. Sorry? Yeah, yeah. Both the affidavits said so. No, I'll show. Let's look at regulation 8 and 10. That's only on quorum. Yes. My learned friend only handed up. What is regulation 8 and 10? They deal with quorum. And I'm saying specifically that the requisite procedure laid down on the section and with.
No, there is no dispute related to regulation.
Yes.
The question is whether, as per the regulation, actual members participated in the meeting. This is their point.
I'm saying that the procedure required in that regulation has been done, met,
This is what,
was duly followed. We have said so.
How many members are present?
Right, my lord?
There should be no difficulty on at least telling us as to how.
Yes, my lord. There is no difficulty in telling your lordships, my lord. I'll put it on a sheet of paper and give it to your lordship.
Whether any of those members present belong to that 8.1c.
Yes, there was a member from 8.1c as well. That's why we have said on affidavit that we followed the regulation. The regulation required that 8.1c member, that was followed. So, my lord, that was fishing, my lord, because my learned friend does not have any reason to say that the quorum was not met. Now, my lord, in these matters, my lord, the burden still remains with him to at least say that I know for a fact that there was no quorum. He doesn't say that either. He says, I don't know whether there was a quorum. So, my lord, it becomes a prejudicial argument only. It tries to throw the burden on me.
Satisfy your lordship.
Now, this is not correct. This is not correct.
Within his knowledge.
According to you, the presumption is that.
Why is he not placing it before your lordship?
To be valid.
No, no.
And the burden is on the person who challenges the validity.
No, no, my lord. Your lordships,
I am not
your
even
lordships'
at this
judgments
stage-
all say.
Not even at this stage asking that he show it to me. That we will see, my lord, your lordships will. Why does he not show it to you? Neither the learned attorney nor the RBI counsel are willing to share full papers with your lordship. What are they holding back? What are they hiding?
My lord, this is exactly, my lord, the kind of prejudicial submission.
Nothing is being hidden. Of course, I will show it to the court if necessary. The court asks for it.
all right, we will continue tomorrow, right? Tomorrow.
Yes.